The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court. This morning, our panel is Justices Henry and Englander, and I am Gabrielle Wolohojian. Although we are conducting this argument by Zoom because of the ongoing pandemic, all the ordinary rules of our court apply, including that each side receives 15 minutes for oral argument with no rebuttal. With that, I'm going to call the first case on our list, which is Commonwealth versus Joseph F. Moran, case number 2021 P0255. Attorney Gaffney, we're ready whenever you are.
Thank you, Your Honor. Good morning. My name is Edward Gaffney, and I represent the defendant, Joseph Moran. Mr. Moran's appeal today concerns the admission over objection of prior bad act evidence at the trial at which he was convicted of 2 counts of indecent assault and battery on a child and 2 counts of enticement of a child. At the outset, I'd like to address what I think is a fundamental disagreement I have with the Commonwealth and actually with the trial judge's choice of test with respect to the admission of prior bad act evidence. As I understand it, the test as articulated by the SJC is that prior bad act evidence is admissible if it is closely related in time, place, and form of act to the charged conduct. But the test that was used by the trial judge was whether the evidence was connected, not closely related, connected in time, place, or other relevant circumstances.
May I ask you a question about that? Because the judge's test, at least in her written memorandum explaining her ruling, appears to track the language in Commonwealth versus Hanlon.
It does.
And so I take it which is an appeals court case.
Correct.
It has not been overruled, is that correct?
That's right, Your Honor.
So I take it what you're saying, though, is that the language in Hanlon doesn't track the language that the SJC has put in its cases.
Yes, and actually I looked into it because it was a little bit confusing because the language in Hanlon is a quote from an SJC case, Commonwealth versus King. But what happened, I think, where the shift happened, in my opinion, between the SJC original articulation of the test and the test that the Hanlon court articulated, was that in King, the test was articulated in the negative. The King court said that prior bad acts are inadmissible if they are unconnected in time, place, or other relevant circumstances. In other words, the King case said it's not, you can't put it in if any of these three things aren't there. And then in Hanlon, it got flipped into the positive. And so the court—
Can I ask, counsel, is there any case besides Barrett that uses the formulation that you want us to use?
Yes, the most recent articulation of that test is in the DEROSA case, which is a 2015 case. I cited in my brief. It's another prior bad acts case.
Is there any case that turns on your contention that there must be proximity in terms of time, location, and acts? In other words, is there any case that says, oh, the locations weren't the same, therefore the prior bad act shouldn't have been admitted? Or is there any case that says 20 years is too long, end of story?
Let me check, Your Honor. I don't know off the top of my head. I certainly don't think that location has ever been held to have been eliminate the evidence. I don't think that's the case. I do know there are a couple of cases which I want to discuss in a second, but I want to answer Your Honor's question directly and see if I have a case where the length of time was held to be too long. No, I don't think so, Your Honor. I think that
time is always discussed as a relevant factor, but I have not found, or I did not see in the case law, and you will know this case law better than I did not see in the case law a case that said, here's a bright line rule, this is just too long. We didn't have something like that, right?
No.
Hold on for a moment. I don't hold on. Keep arguing. I'm leaving to just pull down DEROSA. Sorry.
Okay. The two cases that I would like to bring to the court's attention on the time issue specifically are Helfont and Jackson. I actually cite two Jackson cases in my brief, but it's the 1994 case in Jackson. In Helfont, that's the one where the doctor was convicted of rape. He went to a patient/victim's apartment, and he injected her with Valium. He drugged her basically and then raped her. On the prior bad act evidence in that case was that 2.5 years ago, he basically did the same thing to two other victims who were his patients. He went to their homes and did the same thing. And the SJC said that 2.5 years, which was the only contested issue in that case, 2.5 years was a close call, but it was admissible. The other case, the Jackson case, was a murder case. And in that case, the defendant was convicted of, the defendant had tied up in a very distinctive manner. He hog-tied the victim, who was naked and heavily intoxicated with alcohol. And the prior bad act evidence in that case was that 2 years, or maybe 2 years and a month earlier, he had done the same thing to another victim. Thankfully, that victim survived, but sorry?
Can I go back to the legal standard for a moment?
Sorry?
Can I go back to the legal standard for a moment?
Sure.
So are you saying that you must have all three considerations in order to admit the prior bad act testimony?
Yes.
Okay, but then what do we do with the cases where there's no identity of location?
I'm sorry, what do we, how do I reconcile that position?
Right, how do we reconcile that with all the cases where prior bad act evidence has been admitted, even though the prior bad act did not take place in the same spot?
Well, courts have addressed this. I mean, it doesn't have to take place in the same spot, but it has to be closely related in place. I mean, that's the articulation of the test. And so,
and no type of place?
Well, courts have interpreted it. For example, the Helfont case, I don't think that the opinion specifically identified like the geographical location of those victims' places, but the victims' homes.
Right. So we're not. So here, for example, you can't be arguing, I don't think, that the previous convictions had to have taken place in the current victim's mother's shop or in the defendant's storage unit. It doesn't.
Well, I can't. No, not that.
It doesn't have to be that precise, correct?
No, absolutely not, Your Honor. Not that precise. But in this case, I mean.
All right. So what we're trying. So I guess you're not really saying that it has to be identity of place.
No.
That place needs to be considered as a factor, that the three things have to be considered as factors.
Well, the three things, yes, they have to be considered as factors, and they all have to be closely related. It's not just that we throw all three together, and if one is very strong and then the other two aren't present, we're still okay.
Why shouldn't that be the rule? What you just articulated, why shouldn't that be the rule? Why shouldn't the rule be that you look at all those factors, you look at time, you look at place, and you look at the identity of the facts, and you weigh them among themselves? And if in fact you have, for example, extraordinary commonality with respect to the facts, that can be that can outweigh the fact that, for example, 20 years have passed.
Your Honor, I think that the SJC did exactly that in the Jackson case. Now, I don't think that they were, and came up with the fact that despite the fact that this is the one with the hogtied victims. So the form of act was virtually identical. The location of these two events, the prior bad acts and the charged conduct, took place within 2 blocks. I mean, it was really close. And the time span was 2 years and 2 months, I think. And the SJC said that it was a close case, and 2 years, 2 months was close to the line. But given the fact, as Justice Englander just said, given the fact that these other 2 factors were so lined up, we're willing to stretch the time to, close to the line, but 2 years and 2 months is about there. In this case, it's 5 years. I think if 2 years and 2 months is close to the line, 5 years is way over the line. That's my argument in this case.
Do you get to the 5 years by measuring it from when he was released from incarceration?
Exactly, Your Honor. The actual, the chronology of this is it was 20 years prior. Bad acts took place 20 years, but he was incarcerated for a big chunk of that time. But
counsel, does the record indicate whether he was supervised for any period of time after he was released?
oh, that's a good question, and I don't know the answer to that. I'm sorry, Your Honor. I just don't know. I believe his sentence was expired. I don't know though whether he was on probation or parole. I just can't remember. I'm sorry about that.
On the location, I mean, if we look at DeRosio, the Supreme Judicial Court seemed to be looking at the characteristics of the location rather than the specific location. And in that case, they said that the acts took place at a time and location when young children were separated from their parents, and where he could create a distraction to touch them. And that was sufficient identity of location. So why wouldn't this similarly be exactly like DeRosio?
Well, DeRosio went on to say that they both happened in Burlington. I mean, that was mentioned in the decision. But those considerations that Your Honor just said, I mean, that's a part of it. I mean, as I explained before, I do not believe that closely related in place means it has to be in the same geographic location. If the Helfand case, like I said, I don't know, but it was the victim's apartments. There are child rape cases where it happens in the defendant's bedroom, even if the defendant's bedroom in the prior bad act happened to be in a different town or something like that. But here we've got the defendant's home, and then we've got a rental storage unit, and then we've got a furniture store. I mean, obviously the defendant and the victim or the complaining witness in the charged conduct, they had to be by themselves. They had to be somewhere where they were together so he could, do this. I think that there needs to be some consideration of that factor, because if it gets handled in a too broad sense, it kind of disappears.
Is this something that the in your view the trial court does or does not have any discretion with respect to the admission of this evidence?
Oh, there's definitely definitely discretion. This is an abuse.
Okay, so if there's discretion, but you seem to be arguing it as a matter of law. That's why I'm struggling with it a little bit, because part of this is a probative versus prejudicial analysis, right?
Well, yes.
But you seem to be arguing, look, if you don't have the identity of these three things as a matter of law, it cannot be introduced. The judge has no discretion.
Oh, well, okay. Yes, Your Honor. The standard is the standard. Whether the judge abused her discretion in applying the standard is, that's where the abuse of discretion analysis comes in.
So then that's really a legal argument, it seems to me. It's an argument that as a matter of law, this evidence could not come in. The judge had no discretion to admit the evidence under the facts of this case.
Oh, well, I would put it the judge abused her discretion, but okay, had no discretion. Yes, the facts of this case did not support a finding, that the judge's discretion, could fall within. It was too far out in time. It was too far away in location. The form of acts was not in dispute at all. And before my time is almost up, Your Honor. Do you want? I just wanted to mention the contradictory instructions and bring that to the court's attention.
Well, we perhaps are going to the same place. So assuming we disagree with you and we think it was within the trial judge's discretion to allow this evidence, are you still arguing that we are required to reverse either because of the jury instructions or for any other reason?
Yes, Your Honor. The jury instructions, I believe, here they are. The jury instructions, I believe, are a critical part of the analysis. Once, again, if the court disagrees with my assessment and the judge didn't abuse her discretion in using that test and then in allowing the evidence in, the instructions were given both at the time of the admission of the evidence and at the end of the trial. That was correct in my opinion, but the content of the instructions themselves was extremely problematic because it was, in my opinion, essentially contradictory. First, the jury was told, based on the judge's intention to make sure they didn't use it for propensity purposes. She said, you cannot use this evidence to form a conclusion that the defendant is more likely to have done something now because he did a similar thing in the past. But then within, I think it was 2 sentences, she said, you may consider the prior bad acts as reflective of the defendant's pattern or common method of conduct. And I think that language just invites the jury to say, well, he did it before, so he probably did it again because that's his pattern.
Is that language from a standard jury instruction?
No. The language, you cannot use this evidence to form a conclusion that the defendant is more likely to have done something now because he did a similar thing in the past. I do not believe that's in the standard.
But what about the language that says you can use it as reflective of Mr. Moran's pattern or common method of conduct?
Yes.
So your argument to us is that language, that's what you care about, right? Not the prior. The statement by the judge, you can't use it for propensity, is accurate, right? Your concern is with language that's in the standard jury instructions.
It is, but Your Honor, in the standard jury instructions are in direct conflict, and I argue this, that they're basically propensity is pattern. You can't tell them you can't use it for propensity, and you can use it for pattern. And I
understand the argument, counsel. The line is sometimes very hard to find between those two concepts, but it is, I think, the line that is drawn by the law. But I appreciate your argument.
Thank you, Your Honor. If there's nothing further.
Let me just check to see if there are any other questions. Nope. Okay, thank you very much, Attorney Gaffney. We have your argument.
Thank you, Your Honor.
Attorney Moriarty.
Good morning, Your Honors. May it please the court, Marina Moriarty on behalf of the Commonwealth. Your Honor, starting with Justice Englander's concern with respect to the factors, I would like to quote from the Robinson case, which is 88 Mass App Court 52. Justice Wolohojian, I believe you were on this panel. And Robertson quotes Hanlon, which quotes King, which is the SJC case. Prior bad acts involving someone other than the victim are admissible so long as they are connected in time, place, or other relevant circumstances to the particular sex offense for which the defendant is being tried.
So how do we reconcile our case law with the language in Barrett and as your opponent points out, also in the DEROSA or whatever the name of that case is that I just read from 2015? How do we reconcile that?
Your Honor, I would suggest that the weighing of factors is a trial court judge's standard issue everyday job, and that in this case the trial court weighed these particular factors, these incredibly strikingly peculiar factors.
Go too far down the road on that answer, unless I'm misunderstanding. You may not have I think Judge Englander is asking something else, which is how are we to reconcile the different formulation of the test, the legal test, that there appears to be between the appeals court cases and the SJC cases? I think that's his question.
I don't think there's really a disagreement between the appeals court cases and the SJC cases. I do think that there is that sexual assault cases are considered different, slightly differently than other prior bad act cases. There's the Commonwealth v. Copney, which is an SJC case from 2014. It's articulated in the same way. The fundamental principle is that the
what's articulated in the same way? Is it articulated in the same way as Hanlon, or is it articulated in the same way as Barrett?
It's the black letter law is that evidence of the defendant's prior bad act may not be used for an improper purpose, and that you have to find a proper purpose for which it may be used. And in assessing the factors, you can consider the individual nature of the prior bad act, the time, the place, the location. And I think that each case turns on its own specific facts in order for this court to decide whether the trial court abused its discretion.
Do you agree that the judge needs to consider those factors?
Yes, Your Honor. I do think that the factors should all be considered. I do think that Judge Fahey in this case did consider the factors very carefully. Obviously, it was a very lengthy motion in limine that took up an entire trial transcript package, and that was continued to be discussed. She considered the distinctiveness of the conduct. There was some extensive discussion about the timeline when the defendant committed the prior acts, when the defendant was incarcerated, when the defendant was released. I would like to point out that that 5 years is the point in time at which the defendant was released from jail to the date of the indictments. The relationship between the improper relationship, I would suggest, between the defendant and this child occurred several years prior, because obviously—
When did it start? Just remind me. He was released in what, 2013, right?
I think it was 2013, Your Honor, yes.
And the events occurred in 2017, right?
The indictment dates were 2017, yes.
But so that's 4 years, roughly. Or he may have been released in 2012. I'm sorry. I think that's right. But when did his relationship with the child begin?
It was 2 years prior to the indictments, approximately 2 years prior to the date of the indictments.
But there's nothing that was indictable until 2017. Is that?
That's fair, Your Honor. Yes, I'm just pointing out that this grooming pattern that the defendant engaged in with this victim is what started prior to the date of the indictments, obviously.
But the criminal acts themselves did not occur until 2017?
Yes, Your Honor.
So what do you say to your brother's reading of the Jackson case? I mean, he says 2 years is right on the line, even with evidence that is strikingly similar with respect to the facts. This is 5 years. That seems like a lot more than 2.
That is what Jackson says, Your Honor. But Hanlon, in Robertson, it was 8 years. In Hanlon, it was decades. I do think that the conduct in Jackson is substantively different than the conduct in this case. Violent acts against an adult is entirely different than sexual assault against a child, for which grooming is obviously required. So I do think that Robertson, which the trial ADA relied on in this case, she cited it in her motion in limine, she argued it to the court. Robertson was 8 years. And so Robertson has not been overruled in any way. And so I would suggest that there's multiple cases that are cited in the Commonwealth's brief that suggest that 5 years is nowhere outside the bounds of reasonableness in these particular circumstances where the facts are so identical in nature.
remind me for a minute about the evidentiary rule on the introduction of prior convictions? So isn't there some kind of time limit?
Off the top of my head, yes, Your Honor, there is. It's statutory. I believe it's felony convictions can be entered in if the defendant testifies as impeachment within 10 years of the conviction. So obviously, we're not dealing with conviction for impeachment purposes here.
Well, but the point of the rule of evidence is it can't be used at all. It's not usable after 10 years, right?
For impeachment purposes, Your Honor.
It's not usable at all. Okay, well, you would say it might be usable for other purposes under 404B. The act, not the criminal conviction, but the act might be usable to show course of conduct, modus operandi, et cetera, right?
Yes, Your Honor.
That's a fair point.
You introduced the conviction.
We introduced the fact that the defendant admitted to certain conduct, Your Honor. The Commonwealth never introduced the fact that the defendant was convicted of these.
You introduced that he pled to them.
Not exactly, Your Honor. My reading of the transcript is that the prosecutor was present, the defendant was placed under oath, and he admitted to certain conduct. So it was.
Which you would say is necessary in order to establish that the conduct occurred.
I think it's the most reliable evidence that the conduct occurred, Your Honor. The defendant's own admission under oath.
Right.
I recognize that this is very unique circumstances all around with respect to the facts of the prior bad acts, how the prior bad acts came in, but I don't think that the fact of how they came in rendered them more unduly prejudicial. I do think
that you could have, I don't know what the charges were in the earlier, the convictions that resulted from the plea, but let's say, I actually do, because you mentioned it in your brief, I think, that right there was a charge of rape, there was a charge of indecent assault and battery. All right, do you agree that the Commonwealth could not have introduced the prior convictions?
Unless the defendant testified and unless the judge made a ruling with respect to whether those convictions would be more prejudicial or more probative than prejudicial with respect to the impeachment purposes, if the defendant testified. I don't know whether they would have been, if the judge had made that finding, if they would have been technically admissible under the statute. I'm sorry.
How could you have introduced those convictions in the Commonwealth's case in chief?
The fact of the convictions, Your Honor, they were not admissible.
Okay, so then on what policy grounds or on what theory would we then admit the facts underlying those convictions to be introduced during the Commonwealth's case in chief?
Okay, I think typically in cases such as this, we would have a victim. In the cases in Robinson, and another victim testified. In Hanlon, there were 4 other victims that testified with respect to the defendant's conduct. In this case, the victims were not available to testify. So the evidence was admitted as a statement by a party opponent. The admissions of the defendant at his plea were admitted. And although it's unusual, it's the Commonwealth's position that evidence is actually the most reliable evidence because it's the defendant's own statement.
But it might be the prejudicial effect of the evidence may not have been increased by the fact that it was a prosecutor who was the witness through whom the evidence came in.
I'm sorry, I don't know off the top of my head that it testified that she was the prosecutor in the case. I'm fairly certain she did not testify to that.
That she was a prosecutor.
I think that's a fact. That's what made her present in the courtroom. Again, I do recognize that it has an increased prejudicial effect, but it's also
Have any
An increased prejudicial effect over having the victims get on the stand and testify? I don't know.
Arguably.
Do you have, are there any other cases where we've let this kind of evidence in through this kind of witness?
The Commonwealth was not able to find any cases directly on point, Your Honor.
Was there an objection to having the evidence come in this fashion, as opposed to an objection to the evidence overall? In other words, there are two different ways to object. One objection is prior bad acts can't come in, they're being used for propensity. Another is, even if you're going to allow the prior bad acts to come in, can't put them in through a prosecutor in this fashion.
I know there was notice objections because the prosecutor, because Lisa Jacobs Rossman's name was not provided earlier. And in fact, Your Honor, I'm just reviewing the transcripts dated. But to answer Justice Englander's question, I don't think there was a specific objection to this testimony. Ms. Jacobs Rossman did not testify that she was a prosecutor. She said she presently did real estate, was at home most of the time with her kids, lived in Needham, Massachusetts, and then was just asked, as of 1999, were you familiar with the defendant, identified the defendant, and then went through the questions that he answered under oath. So the jury.
What page of that is? Where are you in the record?
Yes, Your Honor. It's the transcript dated December 10th. Her testimony starts on page 145, and I'm citing page 146.
Okay. The defendant is arguing there's a difference between these standards closely related in time, place, and form of acts versus connected in time, place, or other relevant circumstances. Do you think there's a material difference?
I don't, Your Honor. I just think it's the court instructing the trial judge to weigh and balance the factors that are relevant in the particular case, because I don't think there's one formulation that will encompass all prior, that would fairly encompass the factors that should be considered in all prior bad act cases.
So go ahead.
Oh, no, thank you.
The defendant argues that pattern or common method of conduct is really just propensity by another name. I mean, he's basically challenging the standard jury instructions. What do you say to that?
I agree. I agree it's a fine line, Your Honor, but it is the state of the law. It is within the standard jury instructions. There are numerous cases that Robertson, as I've mentioned, Hanlon, Igubita, all sexual assault cases that talk about pattern conduct with respect to.
I mean, it's not just sexual assault cases. The distinction is between putting something in to show that someone is bad and putting something in because it has a distinctive set of facts, which are in themselves track facts that are alleged to have occurred in the other case, in the case at bar, right?
Yes, sir.
When they use pattern, yeah, it's imprecise word, but that's what it's being used for. And I think there are cases that talk about the distinctiveness of the act, right?
Absolutely. That's where modus operandi often comes into place. Again, Coppney was a SJC homicide case where the court permitted a prior marijuana deal gone bad to be admitted as proof of the defendant's intent and modus operandi with respect to the current case, where the Commonwealth theory was that the current case was a drug deal gone bad. I see my time has expired. If the court has no further questions of Commonwealth.
I do. What was the name of the case you were just discussing? I didn't hear you.
I'm sorry, Your Honor. The marijuana deal case?
Yes.
It's Commonwealth v. Coppney, 468 Mass 405.
That's fine. I did have one other question for you, which was that the judge's written decision on admissibility of the earlier incidents, as far as I saw, did not expressly weigh probative value versus prejudicial value. Do you see, is there anywhere in the record where we can tell that the judge made that weighing calculation?
I absolutely, I believe she weighed it multiple times and made multiple comments with respect to that calculation in her oral discussion with the court. I'm sorry, with the parties. And that would be on the first day. I think it's the motion eliminate day. I'm confident that she made with multiple findings with respect to the probative value versus the danger of unfair prejudice.
I'm all set. Thank you.
Great, thank you. I don't see any other questions. Thank you both for your argument. They've been very helpful to us, and the case is submitted. Thank you.
Thank you.
Very
Irish.
helpful.
The case is now being recorded.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting by video conference because of the ongoing pandemic. Despite that, all of the ordinary rules of oral argument apply, which is that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case Commonwealth versus Jorge Rodriguez, case number 2021 P0416. And Attorney Nato, we are ready whenever you are.
Thank you, Your Honor. May it please the court. My name is Stephen Nato. I am an assistant district attorney on behalf of the Bristol District. This case is here on the Commonwealth's appeal from a judgment of the New Bedford District Court allowing a motion to suppress evidence. The Commonwealth is not challenging on appeal the judge's finding that there was an unlawful or warrantless entry into the apartment in this case, and indeed into a locked bedroom within that apartment. I would suggest that is consistent with Detective Lagoa's testimony from the drug unit. This would be on page 33 of the transcript, that he was the one managing the drug investigation in this case, and he applied for the warrant. He testified that he did not take part in any of the entrance by the detective division, and when he arrived on scene with the warrant, all the entry had been conducted.
Why does that matter? I'm sorry, go ahead.
I appreciate the table here, so we're all actual page. Is it also true that the items that are that were suppressed that are at issue in this case were in that locked bedroom?
I believe that's where the bulk of them were. There wasn't much testimony about specifically where they searched in relation to everything.
Attorney Nato, isn't it accurate to say there was no testimony as to where the evidence was located?
That is accurate, yes. But I think what we're dealing with, and the judge's finding here, is that the entire apartment constituted an unlawful entry, or the officers entering into the apartment as a whole was unlawful.
That's not helpful. I'm not sure whether it's helpful to your case or the other person's, but it's certainly not helpful to deciding the case, it seems to me. Did the Commonwealth argue independent source of inevitable discovery at any time?
The prosecutor, not inevitable discovery, the prosecutor made the argument that at the motion hearing, that the initial entry, regardless of whether it was with Ms. Lugo's consent or whether that was a warrantless unlawful entry, that taint was purged by the execution or the issuance of a warrant that did not contain or any information related to that initial entry, or no exploitation of that initial entry to obtain more information for the warrant.
So that's an independent source.
But you.
Go ahead, Judge Henry.
No, you just finished. So Judge Englander just said, isn't what you're arguing right now an independent source argument?
We approached it as a purging the taint, because there was an unlawful entry in this case, and I believe that's consistent with sort of the case law in Webster and Alvarez, which is cited in the brief. Granted, it was a department, but to the extent that that was an unlawful initial entry, the issuance of a warrant untainted by that entry justified the search, and within the purpose of the exclusionary rule would not warrant suppression in this case.
But I guess I'm confused, counsel, because I thought the search warrant application relayed that there had been an entry into the apartment and the events that occurred with the arrest of Ms. Lugo's son and his possession of drugs.
Yes, so that I would suggest, though, was more by way of explaining sort of why the police were in the apartment at that time and why they were applying for the warrant at that time. While some drugs were found in Antonio Lugo's pocket, even kind of excising that and separating that out from the warrant application, I would suggest that was insignificant and does not affect the probable cause determination in and of itself, where there was, a month-long police investigation in this case involving 2 CIs who provided reliable, accurate information in the past. There was independent corroboration by the surveillance here.
Right, but I mean, but under Commonwealth versus Pearson, which the Supreme Judicial Court issued in the last year or so, if you have this tainted situation, you have to prove that the officers subjectively would have applied for a warrant at that time with the information they had. And it seems to me that your brief basically says the opposite, because it says, well, they were in the middle of their investigation when their investigation got stepped on by another group of police officers, and they were like, well, we're in the apartment, so now let's just get a search warrant.
And I think candidly that was the testimony. This was a case, as Lugo testified, these are independent units that were functioning, and it was what he sort of learned, in the process of investigation. Oh, the detective division is in there. Now is the time. But regardless of the misconduct, we do have, following a month-long police investigation, a issuance of a valid warrant, untainted, even excising any reference to that unlawful entry.
May I say that I see a couple of different pieces of information in the warrant application that appeared to be generated by the unlawful entry. The first is that an occupant in the apartment when they arrived had cocaine on him. The second is that they saw the defendant coming up into the apartment. Ties the defendant. The third is that they spoke to the landlord, and he confirmed that the defendant is listed as a renter of the apartment. And the fourth is that the landlord had observed the defendant in the garage earlier that day. So some of those pieces of information go to tie the defendant to the premises for which they're seeking a search warrant, and to corroborate the testimony, not the testimony, but the information from one of the, or both of the CIs. So, I just think we need to be frank that all of that information is included in the warrant application. Why is that enough? Why is that not enough to taint this application with with information that has been obtained by the unlawful entry?
So to the extent that would add to the probable cause analysis, and certainly I agree, it does corroborate some of those details, but I believe the sort of legal approach that the cases have taken for kind of as long as this doctrine has been around is that you excise the tainted portion. So to the extent that that is a tainted portion, because it does relate to the unlawful entry, the question now is, does the untainted portion of the affidavit provide the probable cause? And again, I suggest it does.
But
Those
Kendall,
details
that's the problem. The problem is that in Commonwealth versus Pearson, the SJC acknowledged that it dropped one of the requirements imposed by the United States Supreme Court, which is that we look at whether the officers would have, without the tainted information, sought a search warrant. And it seems like you're agreeing that at that point, they weren't planning to get a search warrant at that moment in time because they were continuing their investigation, strengthening their case.
I do think that's true. And to the extent that Pearson holds otherwise, I do think here you have, they're speaking to a second informant now 72 hours prior to the application for this warrant. So clearly, I think the investigation is ramping up in a way. And there is reason to believe that, the OCIB was after this guy independently of anything that MCU.
But I'm not sure. So Judge Henry is, she's being polite to some degree. She's extremely familiar with the Pearson case, as you may know. She's saying, why isn't Pearson controlling? It's not in the briefs on either side, but that's what she's asking. She's saying, why isn't Pearson controlling?
Well, again, I would just say this is a investigation that was heating up, so it's not purely
so
that.
One thing is that you would say that none of the information that was put in the affidavit that was found out that day was at all necessary to getting a warrant, right?
Right.
Does that matter?
I think it does under the Webster and Alvarez analyses. And I also think that as opposed to, we're evidence being, we're not looking to the sky at all. We are, our evidence is coming from this detective division and they've learned something. So now we are applying based on what they've learned for a warrant here. And I was just suggest that there is a distinction in this case where the investigation of the OCIB unit is sort of proceeding apace. There's an accumulation of information. There's an accumulation of confidential informants. And so they're not sort of exploiting the detective investigation. It's sort of, bringing their own independent investigation to bear. I think that's the crucial distinction. This is an independent
there are no
investigation.
findings. Are there do you think the findings are sufficient at this point? Oh boy, this would just be nightmare. But do you think the findings are sufficient at this point to reach the conclusion you just stated, which is that the investigation which resulted in locating the evidence was in fact entirely independent of what occurred on the day in question?
I think, there are some issues with the findings in this case, as in the first round before the appeals court, some of the findings were insufficient. In the most recent order from Justice Graziano, the supplemental findings he noted were terse. So we are dealing with sort of a limited finding here, but I would suggest that we can.
He did make findings as to the fact that they were independently investigating, is my memory. I just don't have it right at my fingertips.
But, and so that would be consistent with Lagoa's testimony that these are just two sort of completely independent things happening separately from each other.
As Justice Wolohojian points out, though, they are not completely independent, at least in the sense that the warrant affidavit itself contains information from what happened on that day.
Yes, and I would suggest, again, that's more, again, there are some corroborating details of the investigation, but that's, again, more in the way of, this is how the kind of investigation comes to a head. But the information obtained by OCIB essentially predates everything that happened prior to that entry, or predates.
You know what the problem with this case is and why it's so hard for you? Because the New Bedford Police Department, according to the findings of the judge, acted entirely in violation of the Fourth Amendment to the United States Constitution and Article 14 of ours. That's why we got a problem. They went in someplace they
That's fine.
had no probable cause to go into, and they conducted a search they had no probable cause to do. And now we're here for the 5th time as a result. I hope that the police department is aware of that.
And certainly that's been communicated to the prosecutors, to the police liaisons. And again, I believe the Webster court notes that, the sanction for unlawful police conduct in a case like this is a civil remedy, Department of Discipline, sort of. But that, as the narrow question here of
What is the
and
site
certainly
to
we don't seek to
Webster?
minimize-
I was just looking in your brief and I cannot find the site to Webster. Am I missing?
Sorry, Webster is, there's a citation at 22, on page 22. 21.
I
that's
have one question before we conclude. So you argue on page 23 of your brief that there's no indication in the record that the police discovered or searched for the items ultimately seized before Detective Lagoa arrived with the warrant. And you say that Judge McGovern made no findings to the contrary. But doesn't he conclude in the June 26, 2019 order that, and I'm quoting, the police conducted the search of the bedroom in question prior to the arrival of the warrant? Isn't that an indication that they searched before the arrival of the warrant? Am I missing something?
I think that's certainly an indication that they entered into that bedroom and entered certainly into the apartment, which would constitute a search prior to the arrival of the warrant. And again, that's consistent with Lagoa's testimony that the entry had happened prior to him getting there. But I think McGovern's, supplemental finding is that, they kicked in the door prior to the warrant, which not minimizing or excusing that conduct.
He testified that they look, okay, so the judge finds the door is kicked in by the police department. And I don't understand that to be something that you are challenging on appeal as clearly erroneous.
Right.
Okay, and then the only testimony on that subject that I am aware of is that they then took a brief look inside to see if the person they were looking for was there. I don't believe there's any further evidence, and your colleague, I'm sure, will correct me if I'm wrong. I don't believe there's any further evidence that any of the evidence that was seized was identified at that time, located. The evidence was that they looked inside, which you're right, would constitute a search of the room.
Yes. And I'm not sure for the purposes of the taint analysis that if they had sort of in plain view seen drugs, that would affect the validity of a warrant.
That was going to be my next question.
But
Following up on Judge Henry.
You do agree that the burden of proof was on the Commonwealth, right?
Yes, I do understand that, Your Honor. But I do think we have a warrant here clearly supported by probable cause. Even Ms. Lugo does not testify that the police were, turning up the apartment looking for drugs.
What burden of proof is on the Commonwealth?
Yes.
No, what burden of proof? The burden of proof to establish the illegality, I thought, was on the defendant.
Yes, and I think that can be established by way of filing the motion with an affidavit supporting his contention that would then shift, at least that's my kind of recollection of how it works, and then the burden shifts to the Commonwealth to prove that there was no violation of a constitutional right.
If we read Commonwealth v. Pearson to say that the Commonwealth has the burden to demonstrate, I'm just going to read this, that police would have sought the search warrant had the illegal entry not occurred at the time that they sought the search warrant, in fact. So in other words, would you agree that there is no evidence in this record that would support a finding that the Commonwealth was going to seek a search warrant at that moment?
At that precise moment, maybe not, but again, where they're sort of,
I'm just asking, I didn't see any of that in the record either, and so I just want to make sure. Let me see if there are any other questions because your time has expired. Tricky
Sure.
case. No, all right, thank you. I think we'll have to leave it there. Attorney, thank you for your argument. Attorney Frakes, we are ready.
Addressing Judge Englander's argument first. You asked earlier, was there any evidence of where in the apartment, in the room, any evidence at all, any testimony where these contraband was found? Not only is there no testimony that they were found in the bedroom as opposed to the rest of the apartment, but if you look at the return on the search warrant, this is where we usually find language such as the drugs were found in the sock drawer at the top of the bureau, or perhaps cutting agent was found in a dresser drawer. There's no indication in the return of the search warrant where any of these materials were found. They don't even say in the bedroom, which I think is
understand. Thank you, counsel. I understand. And so my follow-up to that would be, does that matter?
Yes, Judge, I think it does, because
Why? Why does it matter?
when a previous justice mentioned that paragraph on page 23 of the Commonwealth brief, well, there is some testimony that the search took place. After the door was kicked in, officers admitted to walking into that room in search of Miss Early or some other human being. But there is no testimony here anywhere or in the return of the search warrant that those materials weren't simply in plain view.
So who has the burden to pick up on
the government has the burden of production, is how I usually refer to it.
I don't understand that. I really am going to have to understand it, I think. I thought before the questions were asked about 2 minutes ago that the burden of proof fell on the defendant to establish a violation of the Constitution and a right to exclusion of the evidence.
I agree.
Including the right to exclusion of the evidence.
That's correct, Judge.
So you have to establish sufficient facts to show that the evidence needs to be excluded.
Yes, I agree.
All right, so if the defendant doesn't establish that the Commonwealth located this evidence before the warrant arrived, does that matter?
Absolutely, Judge. That's Commonwealth versus Guava. That's the crux of my argument. I don't think there's any disagreement here that happened. We all agree.
Whoa, stop. You're saying there's no disagreement as to whether or not the evidence was located before the warrant arrived. I thought you just told me, and I agree, there is no evidence in the warrant return as to where the evidence was located. And I didn't see any evidence in the record as to when the evidence was recovered.
Fair enough, Judge. But the whole apartment was searched upon illegal entry, and the bedroom was searched upon illegal breach of the bedroom.
The bedroom, there is a finding that it was searched.
Can you stop there for a minute?
I'm sorry?
Can you stop there for a minute, please?
We can't.
In your brief, and now, again, just now, you've repeatedly said that the search of the bedroom occurred before the warrant was obtained. And
yes,
I
Judge.
think, okay, I don't believe that there's any testimony that there was a search of the bedroom before the warrant was obtained. What page of the transcript placed the search of the bedroom before the warrant? Or is it that that the door to the bedroom was kicked in before the warrant was obtained? And is that what you're calling the search?
When the police officer kicked the door into the bedroom, he testified that he walked into the bedroom and searched for something, human beings.
Page 21, page 21 of the transcript that I have.
Right. He looked for the woman who they thought they were looking for to begin with. Is there anything in the record that would support a finding that during that search of the bedroom, they located or saw the items that you are seeking to have suppressed?
No. The judge in the first remand, the judge was asked, what is the basis for your allowance of the defendant's motion to suppress? And he said the search took place before the warrant arrived. The judge, obviously, in our business, sometimes you have to draw inferences. And I think this is one of them. I think the judge listened to everything he put.
Counsel, it's an excellent argument, except for this. What evidence is in the record from which the judge could reach the conclusion that any of the seized items were located before the warrant arrived?
Well, the record is, I guess you'd have to take, honestly, it's kind of silent on that issue, Judge Englander. I think you'd have to take the whole record as a whole, and you'd have to draw those inferences. I don't think those are difficult inferences to draw.
Well, maybe, and I'm not sure I would agree, but maybe the judge could have drawn those inferences based on his listening to the testimony of the witnesses, maybe. But are we able to draw it from the finding of the judge under the circumstances here?
I believe so, Judge. And the reason I do is because when the door was kicked in, the police testified they walked in and searched that apartment, in that room.
Now,
Now,
and
they
here's
didn't
what,
say
here,
they searched-
let's all get on the same page. Here's the testimony. The court asked, did you ever enter the room before you received the search warrant? Answer, I didn't know. Question, did anybody else? I don't remember who it was, but somebody did go in to look to see if there was anybody in there, but that was it.
Yes, Judge. And based on that information, I believe that Judge McGovern drew a reasonable inference.
Well, he said there was a search. I agree, that's a search. He went into a room. He looked for
Yes, Judge.
something. But it's not, there's nothing in there, and there was no follow-up on cross-examination. Did you locate a scale? Did you locate any drugs? Did you locate anything that you seized in that room? It's just not there, right?
It isn't there, Judge. I would also point to the return on the search warrant. The police had an opportunity in retrospect to settle this whole thing. If they could have said in that search warrant return what was seized, where it was seized, it wasn't in plain view, etc. I believe that omission is a fair inference.
It gets back to the burden of proof where we started this where we went at the top. Okay, I'm sorry, I've been interrupting a lot. I'm sure other people have questions.
I would just say also that Commonwealth versus Pearson doesn't seem to involve whether or not there was probable cause to search, but more so was the impetus for the search. And I think that's clearly the only reason they went to apply for that search warrant was because the apartment had been breached by the vice cops unbeknownst to OCIB. I'm resting most of my argument on Commonwealth versus Guava, where the search warrant was not present when the search took place. But if you put those two together, you're rounding out the defense's argument here.
So
But here's the problem with that I think. So let's assume that you're entirely correct, that you're entitled to suppress the search and a search that occurs before the search warrant is obtained.
Yes, Judge.
The only evidence, I think, in the record of what that search was breaking down the bedroom door and looking in it for people. And that should be suppressed. And the link, though, between the items you're seeking to suppress, it's hard to see. It's not directly in the evidence. Is it that you're saying that the judge inferred that those items were seen when they broke into the bedroom?
Absolutely.
That's your argument. Okay.
Yes, Judge. I agree with you. The record could have been flushed out a little bit better on cross-examination, but when the remand took place and the judge clarified his reasons for the suppression decision, he said the search took place before the warrant arrived. And implicit in that has to be and seizure of the contraband.
So I don't have.
So, go ahead,
ahead.
Judge Englander.
No, go ahead, Judge Wolohojian.
No.
Uh,
Okay,
can
so
we-
I guess what you're saying is implied in the judge's finding that the search occurred before the warrant was present is an implicit finding that the search that resulted in the contraband you're seeking to suppress was obtained as a result of that search.
I would say, Judge, that if that wasn't the case, there would be a lot more conversation about when those drugs were seized.
So that doesn't compute for this judge.
I
For this
think
judge,
if-
what would compute is that those were questions that should have been asked but weren't. But I'm sorry, go ahead, Judge Henry.
Well, if I understood you correctly, you're basically saying if we look at other search warrant returns, they're very specific about where items were found and who found them, and that the fact that this search warrant return is silent on those issues is in fact quite damning.
I think that's a very fair inference to make. I've never seen a search warrant return that doesn't say specifically where those objects were located. That's the purpose of the return. This one's silent on the whole thing. It doesn't even say they were found in the bedroom.
How can we make these determinations in the first instance ourselves? I mean, I know that the justice of the SJC thought there was no point in a further remand, and it is sort of mind-boggling to think that we would have another remand. But how do we make these findings about inferences and the meaning of the absence of certain information in the return on the warrant? You know, how do we do that, the appeals court?
I think that the defendant's argument would be that there's enough information on the record to support the judge's findings. And I believe that the judge's findings that the search took place prior to the arrival of the warrant clearly infers the evidence was seized as a result.
Yeah, that's okay. I understand that argument. That is, to me, that's not what it says. It says a search, and that's clearly correct because there's testimony that I just read that indicates that a search took place. Can we go back to Pearson, which I apologize for because I don't have it in front of me. So the notion that you need to show that the officers would have engaged in the warrant request even without the tainted information is one, I think, that's directed at whether or not there's a taint from the illegal activity. Let's assume there was illegal activity here. I don't think really that anyone disputes it, at least on the findings of the judge. If independently, let's assume hypothetically what your colleague has argued, independently of the unlawful activity on the day in question, the other officers had engaged in an investigation which led to sufficient information to get a warrant. Where does that leave us with Pearson? Why isn't that independent finding of the information, independent investigation sufficient to avoid Pearson?
Forgive me, Judge, that case is not in front of me either. However, having my understanding of Pearson is the impetus for that warrant execution at that moment wasn't the investigation. If they had all the information they say they had in the affidavit, independent of the taint, then why didn't they go get the affidavit?
Because they were going to conduct their investigation for a longer period of time.
well, then that suggests there wasn't probable cause.
Well, but that, we can make that decision. As part of my hypothetical, assume that there was probable cause independently of the information they found on that day. Does Pearson say that the fact that this, I guess what I'm getting at is it the illegality that must be the impetus for getting the warrant? Because here the testimony, the only testimony was it wasn't that they had done something illegal that was the impetus for getting the warrant. It was that they already were in the darn apartment, so it was time to go get the warrant. Do you understand my question?
Yes. I don't think you can tease those two apart. I think that there is no indication that they were going to get this warrant independent of the breach of the apartment. Everybody agrees the breach of the apartment was illegal, and 6 in one hand, half dozen in the other.
All right, let me see if there are any other questions. This is a interesting and tricky case, and we've all been helped by both of your arguments. So we appreciate that.
Judge Wolohojian, should we ask the parties to submit short submissions on Pearson since neither one of them briefed it?
Sure. Can we have submissions from both of you within the next 2 weeks, no longer than 5 pages each, on solely on Pearson, Commonwealth versus Pearson?
Yes, Your Honor.
Absolutely.
To be clear, we mean the Supreme Judicial Court Commonwealth versus Pearson 486 Mass 809.
Yep.
The case is now being recorded.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting by video conference due to the ongoing pandemic. Although we're conducting oral argument in this fashion, all the ordinary rules of argument, live argument in our courtroom apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the next case on the list, which is Commonwealth versus HASSAN HINSON, case number 2021P0519. And Attorney Rousseff, we're ready whenever you are.
Thank you. Good morning, and may it please the court. My name is Anne Rousseff, and I represent Mr. HINSON. This case is the interlocutory appeal from a denial of a motion to suppress. And the affidavit in this case failed to establish the veracity of the informant. Few affidavits are as thin as this one. It is missing all of the features you would expect to see. There's no predictive detail in this tip. There's no controlled buys. There's no surveillance of the location or really any meaningful police corroboration. Instead, the affiant relies exclusively on the history of cooperation of this informant. And because the validity of the entire search warrant then hinges on the history of cooperation, one might expect that you would find a robust statement about this CI's prior assistance. But instead, the affiant supplies us with 2 sentences, and those sentences are vague, ambiguous, and leave a lot of questions unanswered. I think some of the biggest questions are, how many tips are there? Was there 1 tip that led to 3 arrests, or were there 3 separate tips in unrelated cases? When were these tips or tips?
Why does that matter? I mean, a confidential informant, I don't think you're probably going to argue that there needs to be a certain threshold of, like, a confidential informant could be reliable even if it's the first time the confidential informant provides information, correct?
Yes, I think that's true. I think in terms of this ambiguity about the number of tips, I would point the court to Mejia, an SJC case from 1991, where in that case, the affidavit described that the informant had provided information leading to the arrest of 3 named individuals. And in that case, the SJC said the history of cooperation was, quote, less than certain when it doesn't specify whether you have one tip leading to 3 arrests or 3 separate tips. So I think, police departments.
Magia is the case that throws out the finds that there's a violation because it's just arrests and not conviction, right?
Yes, that's correct. But
it's also just arrests and not finding contraband, right? And so there's a case that comes after Magia that says if you find contraband, that really, really changes the whole nature of it, right?
Right, and I think the court's referring to Presiding, which is another SJC case from 1991, one of a spate of cases dealing with these interesting issues. And Presiding is very different than this case because there's a whole host of other pieces of information in Presiding. First of all, we know that
I understand the argument, counsel. I understand the argument. There is no case, though, on your side, right? There's no case that throws out a affidavit on the basis of the reliability of the CI, where there's a statement that the CI has previously provided information that led to the location of contraband.
That's correct. I think this case, the affidavit in this case, though, is such an outlier because all of the cases relied upon by the Commonwealth all have significantly more information. I think taking Crawford as an example, that's a case the Commonwealth relies upon heavily.
Why isn't it enough? It's all about practicality, right? And the only words are probable cause. Why isn't it enough for a warrant affidavit sworn to by a police officer to say, not going to tell you this person's name, but this person has previously provided information to me that has led to the location of contraband. The case is currently pending. I've now taken out of it the issue of whether it's 3 and what was actually found and just said, this is it.
Right. So I think we know that an affiant just saying, I've received information from a reliable informant. That's not sufficient, right? There has to be some way for the magistrate to make an independent assessment of reliability. And when you look at the SJC cases and when you look at the facts in Lapine and Grady and Presiding, I think harmonizing all of those things, what you have in this case is a tip that is not detailed. It's not self-verifying, right? There's no predictive value. So you have 3 avenues that the case law lays out to allow you to establish veracity here. One is the Presiding avenue, which is provide the identifying information about these instances of prior assistance. That's one. The second would be the Grady avenue, which is I'm not going to tell you the names of those people, but I'm going to provide you with so much detail about the information provided by the CI, what the police did with that information, how that led to these seizures, arrests, and ultimately charges, so that the magistrate can actually look at that and connect the dots and see the direct link between information provided and seizure. If
the cases say that, because here's what I
want to hear can we hear the third one though before we lose this track? Sorry, we're not going to get back to it if we don't.
Thank you so much. So I would say that the third option, if the police make the deliberate choice not to take door number 1 or door number 2, the third option is corroboration. Do a controlled buy, do surveillance, see if if there's high traffic going to this location. Are there known drug users?
Agree that the 3 avenues are not completely independent or mutually exclusive. Reliability and veracity or basis of knowledge and reliability can be determined by looking at all 3, like information that might fall under each of those 3 categories?
I think certainly because, the cases teach us that you can bolster veracity in any number of ways.
I think that's correct, that you can look at it all. So here, we can't really look at only the information about the history of the CI, correct? So we have have on that is he's provided reliable information which led to 3 arrests and seizures, crack cocaine, heroin, and prescription pills. All 3 cases are still pending in court. And I think what we can take from that is that this is fairly recent in the sense that the cases are still pending, that they led to the seizure of contraband, and they led to both 3 arrests and 3 cases, which would probably allow an inference that it's 3 different people being charged in those cases. Correct? And then we have the information that the CI provides about this particular defendant, the current defendant, Mr. Hinson, which is pretty detailed. What he's purchased, when he's purchased it, it's recent, where he's purchased it, and he knows, for example, who lives at the place where he's purchased the contraband. And then we also know that the police are able to verify the information about the physical location, the resident, and who lives there. And it corroborates what the CI has told the police. All right. Why? And then the confidential informant also identifies the defendant from the RMZ photograph. Why is that not enough on a probable cause standard of proof to establish that the CI is reliable?
So if I could address.
There could, of course, be more. We're never talking about, oh, they're stronger cases, right? That's right. We have to know why it is that this case is not enough. Like, what threshold does this drop below?
Right. Well, if I could speak to the corroboration issue, I think it's clear that the corroboration, such as it is here, is only corroboration of innocent details. Where someone lives, what their living situation is, what they look like, that does not really corroborate that there's any criminal activity going on. So I would submit that that's not very meaningful corroboration. And I think the issue is that the police choose to rely on the history of corroboration, the history of cooperation. And there is simply no published case that has allowed something this bereft of detail, this bereft of corroboration to stand. I think if you synthesize all of the holdings from the cases in this area, you end up with, if they don't want to provide any identifying information, then they have to provide some meaningful detail for the magistrate to see how this prior information actually led to the seizures. The type of really precise detail that you see, for instance, in Grady, where the affiant there said, this person described the location and gave a physical description of someone who's selling cocaine. That person apparently sells cocaine packaged for sale, and they secrete it in their groin area. And then the police go to that location, they find the person, lo and behold, there's 20 bags of cocaine in this man's groin. So the magistrate has those facts before him or her so that they can actually judge the reliability themselves. And I think absent—
Counsel, what is the slimmest case? Because you seem to be thinking we would lower the bar if we don't have the suppression here. So what is the slimmest case from your point of view? And I'll be asking Ms. Lee that too.
I think the Grady might be the slimmest case because there's no identifying information, but there is a lot of detail about the past cooperation in that it actually describes what information was provided and what the police did with it. It's complicated because there's these multi-factor analyses in all of these cases. So I would say, Grady kind of stands apart in that there's no other corroboration and there's no identifying information about that past cooperation. But in the absence of those two things, what the affiant does in Grady is go to extreme detail to justify the reliability of the informant. So I would point to Grady as that case.
So the Commonwealth argues here that if the defendant has concerns about the police manufacturing an informant out of whole cloth, that the defendant could have filed a motion under Amaral and Franks, but didn't do that. What do you say to that?
I don't think Franks is an issue here. I mean, this issue is the sufficiency of the affidavit, whether it's provided enough information for the magistrate to do their job, to evaluate the reliability of the informant, or is this affidavit so lacking in specificity that the affiant is essentially asking the magistrate to act as a rubber stamp? So this is just about the sufficiency of the information provided to the magistrate.
You know, it's a funny way to think about the world because, of course, there is someone between all that information and the magistrate, and it's the police officer whose name is on that affidavit, right? And the way that you look at the world, counsel, and I agree that it's in the cases in terms of reliability is as if that's irrelevant. It certainly wasn't the way the probable cause and the warrant requirement was written in the 1700s. It was not irrelevant at all. It was really darn important because the magistrate probably knew most of the people who came before them. But it's an interesting way to look at the world. That's just an observation. Sorry.
Judge Englander, did we get back to your question before, though? Because I did ask you to indulge me in letting her.
I think I'm. You asked good questions. I'm all set.
Do we need to know? The part of the issue here is we don't actually know the number of times that the informant has provided tips, right? In other words, if the informant has had success 3 times out of 100 or 3 times out of 3, that is relevant, right?
Mm-hmm. Yes, I think that's one issue, and the ambiguity there I think is important, as the SJC recognized in the Mejia case back in 1991. So the police have been on notice for 30 years that this type of construction may not be sufficient for probable cause, and yet they chose that language, chose these 2 sentences, chose not to do any corroboration, and chose not to provide identifying information. The only other thing I would add just quickly is the Crawford case that the Commonwealth relies heavily upon is readily distinguishable, I think, for several reasons. Most importantly, that is a very detailed and specific tip that's predictive, where the defendant's girlfriend was supposedly coming into South Station on a specific train on a specific day with cocaine, and the defendant was going to be there meeting there. The police arrive at South Station at the right time, in the right place, and lo and behold, there they are. So I think Crawford is very different than the facts in this case.
Thank you. I don't see any other questions. We have your argument. Attorney Lee.
Good morning. May it please the court. Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. I'll jump right to the question that was previously asked on the Slimmest case. And not surprisingly, my sister has already addressed it, which is, I think, Crawford. Crawford, I think it's probably the Slimmest case because it was remanded for another hearing on credibility, and it got suppressed again, and it went back to the Supreme Judicial Court, and the Supreme Judicial Court said that there was no basis to suppress the evidence there. And in that case, the CI had given information in the past year leading to the arrest and indictment of 2 unnamed persons and the seizure of 1 kilogram of cocaine. So in our case, we have the informant provided information that led to 3 arrests and seizures of crack cocaine, heroin, and prescription pills. All 3 cases are still pending. We don't know if that was in the course of.
Are we being silly, though, in not asking how many tips in total that the person has provided? Don't we need, I don't know if we'd be a denominator here, but we need a universe. Because, I mean, do you agree if the person provided 100 tips and 3 of them resulted in the seizure of cocaine, then that should not get a search warrant? Or maybe you think it should, and I'd like to know why.
So I think if a person has been wholly unreliable, as 97 fails and 3 successes would suggest, then the affiant should be including that in the search warrant affidavit.
How do we
and
know
you're not,
that they're not?
well, that is on the truthfulness of the affiant, which is the Franks issue that my sister has just conceded is not relevant here, because that is the defendant's burden to bring that motion. We don't presume the affiant is lying. They're swearing under oath as an officer who is a police officer within the state or community. And so I would suggest we don't presume that the officer is lying. We take the 4 corners analysis and look for probable cause. And so, so I think that this case, we cannot tell, you're not being silly, we cannot tell if this is 1 investigation or 3 investigations, and that would have been helpful information to hear about. You could draw the inference, because it's got 3 different kinds of drugs and 3 different people, that it's 3 cases, but you can't tell that. And as I said, we're stuck with the 4 corner information. So even if this is just 1 tip, this is still sufficient, as it was in Crawford. This is the language. I understand my sister has done a very good job in her brief, pointing out this case has more, this case has this, and looking at the background facts. Certainly a lot of research went into it, but what we are bound by, and that is both my sister and I and this court are bound by the language of the Supreme Judicial Court. And that language in Perez-Baez is that the important detail that is necessary in describing the tip is the seizure of contraband, and that's in Perez-Baez. And it said that distinction is critical. And that is the point of all the cases I've cited in the Commonwealth's brief that we are bound by. When a confidential informant has provided information that has led to the seizure of contraband, that person can deemed to be truthful. And I should have pointed this out in my brief. I wish I had. In terms of how recent is this? And we can draw the inference that there's some recency from the fact that the cases are still pending. But I would point out in the DiPietro case, which is cited in the Commonwealth's brief, that's at 35 Mass Ave Court at page 642. It says the passage of time, however, does not usually erode one's truth-telling propensities. So we're looking at probable cause. We're looking at the language from the Supreme Judicial Court. That language in Perez-Baez that was relied upon by the motion judge is that the critical distinction, the critical detail is whether that informant has provided information in the past leading to the seizure of contraband. And this informant has. That's the minimum. I'm sorry?
Is that assessment to be made? What is the quantum by which that assessment is to be made? Probable cause?
I think that that's correct. I'm trying to think how it's phrased under Aguilar-Spinelli, because we usually talk about the 2 prongs, and then that informant is shown to be reliable, and then the information from the informant leads to probable cause. So it seems kind of funny to say you have to have probable cause to show veracity, but I feel comfortable saying you need probable cause to show veracity, that this person's probably telling the truth. And the person previously told us the truth and led to the seizure of contraband, so they're probably telling us the truth now. And I think that we can also look to Crawford in terms of the timeliness of it, that they said in the past year was sufficient. So I would suggest in this case, where you have 3 cases still pending, and I think it's unusual to have 3 cases still pending for long periods of time. I understand, as my sister points out,
Is Crawford
some
different
cases,
because of the predictive details?
I don't think it can be distinguished on that point, because it's we're still looking at probable cause.
He intervened after he had observed some of the predictive details to be true. They arrived at a particular place at a particular time, right?
Right, and those kind of I understand that's predictive, but those kind of corroboration of innocent details are the same we have here. The defendant is living in the house with his mother at that address.
Were they all
So
innocent details?
in the affidavit, I'm sorry?
Were they all innocent details in Crawford?
Well, I think there's a difference with predictive details because you have to know something's going to happen. So, I don't know all the details on that point, but I agree. Corroboration of predictive details is a long line of cases that talk about how that is that shows that someone is on the money, that they're correct.
I agree that there was no corroboration of predictive details here.
Oh, yes, I agree. So I understand, and the motion judge noted this as well. This is a slim affidavit, but this affidavit complies with the law that the SJC and this court have set out for what police affiants are supposed to be doing. And the affiant did that here. And looking to, more could have done. I assume surveillance could have been done, but that risks someone being seen, the police officer being seen. And a control buy is by no means like a simple, we'll just go do a control buy. First of all, you have to get agreement from the informant to do the control buy. So that it's not, these corroboration details for secret criminal enterprises are not easy to come by. So here we have.
It wouldn't have been hard to provide more detail about the history of the CIs.
That's correct.
In the police, and that's really where the nub of this case is.
Right.
And that's wholly within the officer's control.
Yes, because the officer wants to draw that line of providing enough information without endangering the informant, which was mentioned in this affidavit. And so I don't think that there's any insinuation of something wrong being done when an officer is trying to provide the minimum bar. They want to get to probable cause and provide the least information so that you have the less likelihood of an informant being identified and being harmed. And here there was a concern in the affidavit that an informant or the informant's family members could be in harm's way. And so I don't think that's a bad interest by an affiant in trying to comply with the law correctly and protecting the informant. But regardless of that, the affidavit has to be sufficient. And I submit to the court that this affidavit, as the motion judge found, though slim, meets that minimum bar under the language in Perez-Baez and under the language in Crawford, of which we are, as I noted earlier, we're all bound.
So counsel, do you contend that the police corroborated any detail that was not innocent? I mean, it was just all observable location and appearance, right?
I just want to be candid with the court. The police affiant put in the defendant's history, and the Commonwealth at the hearing conceded that the history of the defendant was so distant. I think the earliest thing was 10 years earlier. So the police officer was trying to corroborate the informant, but the Commonwealth has conceded at the earlier hearing that information was stale. So I just don't want to undercut what the police officer was trying to do and also not acknowledge our stance on that point at our hearing.
We appreciate the candor.
I'm happy to answer any other questions. The Commonwealth's position is that we're bound by the Supreme Judicial Court rulings and that this affidavit is sufficient. I'm sorry, did I interrupt you?
Well, the defendant essentially is making an argument that an officer could have just made this up because there's so little detail. I don't, I'm not trying to cast aspersions. I'm just trying to understand how do we protect? Is there something in here that protects from that? That's what I guess I'm trying to understand.
Well, what protects from that is the Amaral and Franks proceedings.
Okay.
And police officers know that if there's a claim brought under Amaral and Franks, which are not uncommon, I mean, there's lots of cases citing Franks v. Delaware, so it's not uncommon. Police officers know that they could get called to an in-camera hearing and have to explain who this informant is or what these cases are, even if they don't have to identify the informant. So in the same manner that we know informants have some interest, self-interest, selfish interest to provide correct and true information to police officers, because if they get caught, they will be in a very bad and unfavorable situation. That same manner is what guides not just police officers, but lawyers and everybody else. That's why we sign things under oath. There's a lot at stake for putting in a blatantly false lie into an affidavit, which is why we require the defendant to shoulder the burden at a Franks and Amaral hearing. But the defendant is not left without recourse. If they think that this is a lie, they can do the research and the factual research and bring a Franks and Amaral hearing.
And I would add to that there are a lot of affidavits that are that don't involve confidential informants, where warrants are issued based on what police officers say, where the only thing that you have is the police officer's observations, and in those cases, the way that we are protected is the same way. The police officer has to be telling the truth. They sign it under oath.
And I don't want my comments to be taken in a manner that suggests that we at the Bristol District Attorney's Office or the Commonwealth generally are not concerned about that. Obviously, that is of the utmost importance that affidavits signed under oath and presented to a court are truthful and honest, and that our whole system is based on it. I would ask this court to...
Let me see if there are any other questions. All right, is there anything else you want to add, Attorney Lee?
I would just ask the court to affirm the motion judge's ruling, and I thank you very much for your time.
Not at all. We appreciate both of your arguments. It's an interesting case. We've been helped by your briefs and also by the arguments today. The case is submitted.
The case is now being recorded.
Good morning and welcome to this sitting of the Massachusetts Appeals Court. I'm Gabrielle Wolohojian, and with me today are Justices Henry and Englander. We are conducting today's argument by video conference because of the ongoing pandemic. However, all the ordinary rules of our court still apply. This includes that each side is allotted 15 minutes for oral argument with no rebuttal. With that, I'm going to call the next case, THERESA SYNAKOWSKI versus Christopher Costa and Associates, Inc. and others. Case number 2021-P0425. And Attorney Markoff, we're ready whenever you are.
Thank you. May it please the court. My name is Michael Markoff. I represent the appellants and defendants in this case, Christopher Costa and Associates, Inc., which I'll call the company, and Christopher Costa, the individual, who I'll probably call Christopher Costa. This is the case about the surveyor and the survey. And I think probably the easiest starting point, I wish I could do this more elegantly, but the key document is the first plan that was dated 2011. It's Trial Exhibit 4. I'm just going to hold it up briefly, just if that does any good. But do
you want to tell us the page number of the
yes,
record?
It is Record Appendix Volume 4, page 7.
Okay, so we'll pull all of those up on our own screen,
okay,
and then we'll all be on the same page.
Thank you, Your Honor.
Yep,
The,
you got it.
Okay, as you can see, this is the document that basically gives rise to this case. It shows an existing building that's on a lot owned by Ms. SYNAKOWSKI. It shows a proposed addition to that property. It shows an easement or the boundary line, sideline of electric transmission line, and it shows a portion of the proposed addition is going to be located inside the easement area. And the background that gave rise to this plan, I'll try to do the facts relatively briefly because I know you've had an opportunity to review the documents. But Christopher Costa, one of the defendants, is a licensed surveyor. He's a registered surveyor in Massachusetts. Christopher Costa and Associates is the company that employed him. David French was an employee of the company. He was a CAD, meaning computer operator, and he was also a survey crew manager. And Ms. SYNAKOWSKI, the plaintiff below and the appellee here, owns the property that's shown in Exhibit 4.
About this plan. There's certification language in the bottom right-hand corner of the plan. I hereby certify, blah, blah, blah. Is that language prescribed language by regulation or any other means? Or is that certification language something that is determined surveyor by surveyor?
The answer is a little bit different. That language is based on what the plan is being used for. So in this case, the plan was going to be used to get a building permit. In order to get the building permit, the surveyor has to certify that the plan complies with the zoning setbacks and all other zoning regulations. And you'll see on the plan, it's on the right-hand side, just above the square. It has a total lot coverage and a total lot coverage by structures. That's part of the information that the town needs in order to grant a building permit, because you have to show that the total building.
How was that? So what it sounds to me you are articulating is the rules and regulations to get a building permit in that town.
Yes.
How was that put into evidence?
That was put into evidence by our building expert, Mr.
So someone testified. That's why.
Yeah, somebody testified to that.
Okay. All right.
And he testified that each town is slightly different. And I really apologize for this one, but I'm now blocking on my own witness's name, so I do apologize.
No, that's all right.
But the certification indicates that it's for a mortgage inspection, and that was not the case, was it?
No, it wasn't, Your Honor. That language, I think, is added, and I don't think there was any testimony about this, but most people, when they build things, they need mortgage money. And so that's simply put in there on the assumption that it might be needed. So it wasn't specifically requested. That was added probably by course of the business. But it really didn't refer to this case.
Counsel, maybe we can jump ahead because there are a lot of issues in this case. There is, as I understand it, your opponent would say that he proved a breach of duty, at least two different breaches of duty, and that relevant breaches of duty. And one of them is a failure by your client to warn the plaintiff that she's got a problem because she's encroaching on that easement. In other words, to either put something on the plan or orally separate from that. Why isn't that an enforceable, why isn't that your client's duty, and why isn't that an enforceable claim in negligence?
The reason is that duty is not imposed anywhere outside, maybe, of this case, depending what this court's decision is going to be.
Well, but wait a second. I mean, it's a claim for professional negligence, right?
Yes.
Okay. And there was someone who testified that a professional fails in their standard of care if they don't perform this particular thing, if they don't make this warning, right?
Yes.
And that was someone who was qualified as an expert, and did the evidence come in over objection, or?
Yeah, well, partially it did, but as for this specific opinion, the basis of our objection primarily is twofold. First of all, that Mr. Giosi, who was the expert, had nothing to back up this opinion other than his opinion. There's no regulation he cited as to the duty to warn for something that's not a part of the plan itself. In other words, not a mismeasurement. There was no prior case law. There were no regulations. There was nothing. Secondly, in the court, after this litigation started.
So was there like a Daubert-Lanigan kind of objection that he should not be allowed to give this opinion?
I don't think we phrased it that way. The way we phrased it was that there was during the course of this litigation, after this complaint had been filed, Ms. SYNAKOWSKI filed a complaint with the Division of Public Licensure, essentially raising the same issue. The Division of Public Licensure took her complaint. It had the plan that we just looked at. It had, I think, 10 pages of commentary by her.
This is the collateral estoppel argument, and
yes,
and I will redirect you off that argument. I think,
okay.
Counsel. Better time spent answering the questions that are asked.
Okay. Well, I was trying to do that, sir. So then we go back to the simple issue
the
that
problem is that but there was an expert for her that gave this opinion, and the contractor she did use, Dolph, said he would have expected a surveyor to raise this. So here you've got a guy who's in the business who says, yeah, I think not only does he think that the surveyor would have raised it, but he thinks they should have called and flagged it, not just waited to be inquired of.
No, I think, Your Honor, I believe his testimony was that had he been acting as the general contractor, he would have pursued it. I don't think he testified that he expected people to come to him. And the reason he did not pursue it is that he was not the general contractor. Ms. SYNAKOWSKI was her own general contractor. And
Was
that
there
gets to the
a written contract between your client and Ms. SYNAKOWSKI?
Yes, it's one of the early exhibits in the.
And does the written contract just define a scope of work?
Yes, and that was what our building expert went over. He testified that in viewing the scope of work, that the company had fully satisfied the scope of work.
I'm less interested in what your expert testified to and much more interested in what the legal document says.
Oh,
because the jury could have rejected everything that your client said, that your witnesses said, and that's the shape you're in at this point, having taken an adverse jury verdict, Counsel.
Sure.
But the contract defined a scope of work. Did the contract say anything at all about providing warnings of any sort?
Absolutely not. Let me rephrase that. My strong memory is absolutely not, but the document is in the exhibit book. But it does not, I don't believe it says, it simply says what they are going to do, which is basically create the plan and then come back and do measurements after the foundation is poured.
It's volume 4, page 5.
Thank you.
4 and 5. Let me ask you, can I ask different questions? I'd like to look at the verdict form, the special verdict form. So here, and I'll ask your opponent the same question. It appears to me that the jury found that Mr. French made misrepresentations to the plaintiff, but they then determined that they weren't made with the intention that she relied on them.
Yes.
Right. So there was no liability on the fraud claim. However, the only statement, as far as I can tell, that he is alleged to have made that was false was her testimony, that French told her that she could build in the easement area.
Yes, Your Honor. And if can I comment?
Well, I haven't even gotten to my question yet.
I'm sorry, Your Honor.
And so if the jury found that French made that false statement, why is that not, even if there was no duty on COSTA or the company by virtue of custom or practice of the industry or the regulations, but when he makes an affirmative false statement about it, why does that not create the duty for the negligence claim? In other words, once he affirmatively makes that statement, why haven't they themselves undertaken the duty?
Well, the reason, Your Honor, I believe, Your Honor, the answer to that question is that the statement that Ms. SYNAKOWSKI attributed to French could not possibly have been accepted by the jury, because one of the questions was, was a statement made with the intent that the person rely on it? And according to SYNAKOWSKI, she turned to French upon picking up the plan and said, pointed to the easement and said, can I build there? And French replied, yes, you can. That's clearly with the intent of telling her that she can rely on what he's saying. So that can't be what the jury believed. They probably believe.
Why is it important? We can't do what you're suggesting, I don't think, counsel, which is why I'm interrupting, and I apologize. But why is it important whether he had the intent that she rely on it? If he says it and he's negligent, I saw that question was asked. I assume that question went to the jury without objection. I do not understand why that question is at all relevant to a question of negligent misrepresentation. Why does it matter what his intent was?
Well, for two reasons, Your Honor. One is that the negligence is that of the company and of Mr. Costa, not of Mr. French. So Mr. French's statement has to be foreseeable in some way. Mr. French testified that he not only did not make it, but that he knew he wasn't supposed to make it. That's not contradicted.
Yeah, and the jury must have rejected that because they found that he made they found that he made a false statement.
But
just by analogy, if you had, I'm sure every moving company out there tells their drivers don't speed, but if they speed and they hit somebody, then the company is going to be sued. And we're not going to say, oh, well, you did in your training, told them not to speed, so there's no liability, right? I mean, isn't that what the situation?
Yeah, but if I may, it's because I'm so much close to out of time, may I just make two comments, because I think they relate to this, but they're also major for me. One is that if this were simply a negligence case, I can certainly understand. I stand with what we've argued, but I understand it. However, this was a 93A case. This was a case where there was allegedly an intentional misrepresentation, a unfair business practice. The company couldn't have done that. They didn't. They had no way of knowing.
Counsel, you may well be right that finding by the jury has some relevance to 93A, but we're back on negligence, which you argue there was no showing of a duty. And Judge Wolohojian's question was, why hasn't there been some sort of assumption of duty if he makes an affirmative representation that she can build?
And again, my response is tied to the jury answer. But may I make two other comments, because I can see I'm down to 11 seconds. One,
if I could, I think we may all have additional questions, and you should continue to answer them as long as they come at you.
Thank you, Your Honor. Then again, my argument here is that if Mr. French he made some statement, that was not foreseeable to the company that he would make that particular statement. Not that speeding might be foreseeable, but that an employee who knows he's not supposed to comment on legal issues,
but
go ahead.
I don't understand that argument. He is an employee of the company who is placed in a position where he is giving advice to a client.
But to that thing, he wasn't. The testimony was that Ms. SYNAKOWSKI simply came to pick up the plan, that Mr. French just happened to be there because he works in the company, that he was the one who handed her the plan, that she then pointed to the easement and said, can I build there? and that he then volunteered an opinion which he knew he wasn't supposed to give. Again, assuming that he gave it, but he knew he wasn't.
That's assuming the jury believed him.
Well,
That's
again, though,
the problem.
if you look at the jury answer, they could not have believed that the transaction, the incident happened, as Ms. SYNAKOWSKI said, because of the way they answered the question of reliance.
I don't think that's all self-evident from the few questions that were posed to the jury. And since it is not self-evident, I do not think as an appellate court that we can reach that assumption. You know, your argument sounds to me like the company is saying it is not responsible for what French did. I didn't see that in your briefs, and I don't understand that to be an argument that anyone could make under these circumstances. French was the person who had the only contact with the plaintiff. So you're left with this situation where he made a representation. Now, there may be other arguments, and in fact, it seems to me there are, because.
Well, let me see if there are any other questions.
I'm sure I have some, but if you guys don't have any.
I guess a bottom line question for me is, let's assume that the jury believed that French told her, you can build there. And I recognize that you don't agree with that, but we would like your input on what the significance of that would mean. And you can choose not to give it to us and then leave us to wander in the woods by ourselves, or you could give us some direction. And I say it that way because sometimes people really want us to just wander in the woods by ourselves, but I would encourage you to give us some input.
The input would be that clearly, if you reach that conclusion, that would clearly weigh in favor of affirming the negligence count, but it does not address the 93A count, which I had hoped I'd be able to talk about. So if I can just have 10, 15 seconds to say that the 93A count was based almost entirely on allegations that that Mr. Costa had violated numerous regulations. There's laid out in my brief, and the main point, there are a couple others, but the main point I just leave the court with is that none of those alleged violations had anything to do with the facts of this case. In this case, the theory the plaintiff was going on was that Costa failed to supervise French. But the error in this case, if the court finds there is one, is made by Mr. Costa himself. He's the only person who can put the warning on the plan. If he fails to put the warning on the plan and the court determines that was his duty, then he's breached his duty. But it has nothing to do with supervising French, and it has nothing to do with 93A claims.
Right, but French made a statement. French made a statement the jury found to be false. The judge explicitly found that Costa was not supervising French.
And that's the point, that there was no evidence to support that, nor was it relevant, because French constantly denied ever having to make the comments. So there's no way.
Are you arguing the judge's finding was clearly erroneous?
I don't think
he made a finding of fact in connection with the 93A.
No, I don't think
your client that Costa was not supervising French.
No, I believe yes. The judge simply is based on the alleged violations of the regulations, which had nothing to do with the error that Costa was supposed to have made. That was my main problem with the 93A claim.
Understand it, and we're going to have to leave it there because your time is up. Attorney Markey.
Good afternoon, Your Honor. May it please the court. Attorney John Markey Jr. on behalf of the plaintiff appellee THERESA SYNAKOWSKI. I do think that Justice Englander's question about the contract was a good place to start as to where a duty arises and why my client ended up in this unfortunate position. On the scope of work, it clearly states that the goal is to prepare a certified plot plan showing a new addition. The only reason my client went to Mr. Costa's office was to get a plan that could be used to build a new addition.
She went to get a plan so that she could then get a building permit. And
Correct.
Isn't that what the evidence was?
Yes, she was told by
was the plan itself sufficient to get a building permit without any warning that you say should be on it?
The plan, what it turned out to be sufficient, that the building inspector or nobody else interceded to protect her, but it set into a course of events. If I come to any professional, whether it be a lawyer or a doctor or a surveyor, and I say the principal purpose of my contract is to accomplish a particular objective, I, as a
Sure, but
professional,
with all due respect, I don't think this argument is going to help you, at least for me. Because if you came to a lawyer and you asked them and said, I need help with a medical decision, there would be some boundary on what the lawyer's duty actually was, because, you know, what duty is there on a lawyer to provide you with medical advice? I read all of the CMRs pertaining to surveyors. And I take it that your argument is that the duty on COSTA comes from his obligations under the CMR for surveyors. And your argument, and correct me if I'm wrong, is that he had a duty to disclose on the plot plan what the legal consequences were of the easement going through the land, correct? That
no.
he was required to say, there's an easement you can't build on. Are you that should have been on the plot plan?
our expert said that's one option. Our expert, Steve Giosa, said there's three things. First,
Attorney Markey, I may be mistaken, but it's helpful, at least to me, if I ask a question that's like a yes/no type of question, that you be able to tell me yes or no and not refer to some witnesses.
The answer is no, then, Your Honor. Sorry.
Okay.
The answer would be
So
no.
you know he had an obligation to disclose that on the plot plan.
That if he prepared the plan, he should have put it on the plan. The testimony is,
what should he have put on the plan?
it should have said, this project cannot be built unless you receive permission from NSTAR to build.
Is there any CMR that would have imposed that obligation on COSTA?
It's the only CMR, not to talk about explicitly to warn. The testimony.
Okay, let's leave it there because I looked at CMRs carefully, and I will tell you frankly, the CMRs for surveyors seem to me to be very clearly directed to the obligation to correctly record physical characteristics of land. I see nothing in the CMRs that require surveyors to opine on the legal consequences of things that exist in the physical world. Would you agree with me that there's nothing in the CMRs about that?
I agree that there's nothing explicitly in that.
So then we need to ask, what is the duty in your view, and where did it come from that supports the verdict, the negligence verdict against COSTA?
The duty arises from the fact that if you would contract with someone and their primary purpose of the contract from which the duty arises is to build an addition, and there is a major impediment to that primary purpose, our expert said you should never even complete the plan until you talk to them about it. If you do move forward with the plan, you need to put it in writing that this is an issue that they must address, because the very reason they're hiring you is for that purpose.
The duty comes from your opinion, your expert's opinion that this is industry practice. Is that correct?
Yes, that is both that it's industry practice and it's the primary purpose of the contract.
Okay, except there's no affirmative statement in the contract about offering opinions on is the project buildable as a legal matter. I didn't see that in the contract. Correct?
That is correct.
Okay, so the duty here that you're relying on to support the the verdict on count one comes from what your expert said.
Yes.
Is there any other duty? Because I thought earlier you said there were 3 sources of negligence liability.
Well, my client said, the expert said, number one, there was three opportunities to deal with this problem. One would be to have a conversation and never make the plan. 2 would be to tell them they needed to get N-star improvement verbally, or 3 would put on the face of the plan, it's an issue that needs to be addressed to draw everybody's attention to it. Because once you release a plan and you have your stamp on it, it will be used by a variety of people in multiple purposes. And if you do not communicate a major issue that will prevent a successful project, you violated your duty.
But aren't you making you're making the surveyor into a lawyer? And I mean, that's basically what your opponent is saying. And I have to say, I think it has resonance with me. I mean, that you go to a surveyor to get a plot plan. The fundamental basis for getting the plot plan is you can't get a building permit without that plan. Plan has to be accurate. No one questions that the plan is accurate. But now you're saying he had another obligation. His obligation went beyond just doing an accurate plot plan. His obligation was to also say, hey, there's an easement that this is in, and what's fill in the blank for me. What else was he going to say? Because I think the rest of it is legal advice.
But it is a major issue for which you must deal with it, or you need to change your plan. So it is in essence like you go to a primary care physician, their job is to say you need to go to an expert to get the further testing. The surveyor is not supposed to dig deep into the easement.
Tells us, so I think that's a great analogy, by the way, because I think that's exactly the world we're in. We're in the world of professional negligence. But what you're saying is that there's an independent and perhaps even goes beyond the scope of the work of the contract. You're saying independently, he had to do something more than just do the plot plan independently. And what's the source of that?
The source of it from the expert is that if there's a primary purpose of a contract, your duty is to address anything that may be a major impediment. And just to explain.
Okay, and let me ask you this. The interpretation of contracts is a matter of law that's conferred to us as judges. So if we look at this contract and we say that the terms of this contract do not create such a duty, where does that leave your expert's opinion? Because your expert was not a lawyer.
Correct. And the contract does give Mr. Costa an opportunity to say he's willing to provide additional services if they are needed and to charge extra. The contract says its primary purpose is to give a plot plan for a new addition. If you know, as an experienced person, Mr. Costa's deposition testimony, which was read in, said, I absolutely knew you couldn't build there, but yet he did not communicate it. He did not instruct his employee to communicate it.
To disclose it. If he has an obligation to disclose it, he breached that obligation. But you can't prove the duty simply by the fact of the breach. Did your client provide to COSTA the actual easement, the legal document?
My client did not do so that I recall, and I don't believe that's in the record. My belief.
Right.
My client.
So it seems to me that your argument is that a surveyor has not only an obligation to go map out the easement, but to go find the easement document and make an interpretation of it to determine whether, and if so, what legal consequences flow from the easement. Because not all easements do the same thing. Some things just say, they protect your view. Some things an easement says, we need to be able to walk on this from time to time. So how is it, without knowing the terms of this specific easement, is COSTA supposed to have an obligation to tell your client that she can't build this addition on the easement?
Two things. I believe my understanding of what's in the file that COSTA had was the easement, because the only way to get the meets and bounds is to get the history of the easement, which includes the restrictions and limitations. So it was in the file and it's all part of a single document. The second piece is, if there were a nuanced interpretation of the easement, I agree that he should not be practicing law. But if it's a close enough call that it could stop your project, cause you to tear down part of a building you've built, I think it's something which you have to say, go to the specialist. There may be an issue here. Or to manage, I'm sorry, Your Honor.
I want you to finish your answer and then I want to ask a follow-up question. Go ahead.
Or to discuss with French that this is an important issue. Do not make any representations and manage him actively. As my client's testimony said, and all the evidence was, the only human being she interacted with from the time she walked in on the first day until this issue arose was David French. He's the one who met with her. He's the one who came out to the site. He's the one who just told her that she could build there. There's no recollection on behalf of French or Christopher Costa that they ever spoke about this project. There's just the testimony that French said he did his work, he left the file in a tray, and it came back, and he then finalized it and got it stamped.
Okay, so I actually just want to go back to to square one. Do you agree that that first and I guess second plot plan show on, they show all the right meets and bounds and the project and the easement? Like, you're not saying anything was wrong with what is actually there, right?
That's correct, Your Honor.
Okay, and your client also had the easement, right?
She knew that there was power lines.
It's in her chain of title.
She didn't physically have the copy of the easement. She just knew an easement existed.
Perhaps, unless Judge Henry has a follow-up on that, maybe we can turn then to the other question of the representation made by French. So you proved a representation that was incorrect made by French. Is that sufficient basis for a negligent claim as opposed to a claim for negligent misrepresentation?
Yes, because he is giving advice to somebody who is contracted with the entity for which he works to provide guidance, and he chose to. I guess you could use it as the analogy again of a doctor. If you stop to help someone, you can't put them in a worse position. And it appears that the jury believed that he did stop and ignorantly believed he was helping her and told her she could build there. So yes, a duty arose then.
Did you argue down below that the duty on COSTA and the company resulted from the affirmative assumption of a duty by French when he gave the incorrect information?
During the course of the trial, that's the reason the evidence went in, Your Honor. We argued both that.
No, you had a negligent misrepresentation claim, and you had a 93A claim. And I have to say, I was entirely confused, and Judge Wolohojian is going to come back to this line of questioning, I hope. But I will say this. The law that I learned was that your negligence claim is only for personal injury or property damage. That got screwed up when we started allowing people to sue in negligence for malpractice. And that seems to me to be what your case is. But usually the hook would be, for a case like this, that it's a negligent misrepresentation claim, which you can get economic loss for. However, you lost your negligent misrepresentation claim. In addition, one of the key elements of that claim, which was not asked of the jury, was whether your client reasonably relied on the statement. Not asked, not answered as far as the jury. Now, with that in mind, how was the case presented?
The evidence was presented, and I believe my best recollection of the closing arguments were that Costa and Christopher Costa and Associates were negligent in going forward with a plan that could never be built, in failing to warn them, and allowing David French to unilaterally interact with a client and give bad advice. Collectively, that was negligence in the way you manage your operation.
So it's a negligence.
Go ahead, Judge Wolohojian.
No, so as I hear you now, it was a negligent supervision case.
And that's what all the CMRs go to as well. The importance, if you have someone underneath you, of interacting with clients or doing work, that they only be assigned to and allowed to do things they're competent to do, which the evidence and our experts said did not occur in this case.
Go ahead.
I do not understand how there is 93A liability here, even if there is negligent liability. What is the unfair and deceptive act and practice? And this is the important part, that proximately caused her loss. I get that all kinds of things may have happened here that shouldn't have happened, but I don't get the connection to her loss.
So her loss would not have occurred if there was a series of events that didn't begin by handing her a plan that would lead to NSTAR issuing the cease and desist and having to force her to tear down the building.
Right, but that's negligence.
Understood, Your Honor. So the question under the CMRs is, if you fail to supervise, the very reason for this regulation is that if you don't supervise someone and you allow them to go out into the public and prepare documents and give advice without supervising them adequately, you can cause damage to people who are relying upon your profession. And so under the CMRs, the series of them that relate to assigning work, supervising work, not putting someone in a position to do so, are key elements as to why French was in this position and why Ms. SYNAKOWSKI ended up where she did.
But so that's an argument that says that violation of the CMRs alone is sufficient to establish an unfair and deceptive practice.
Not necessarily. My view is that this was a 7-day trial and Judge Gilday heard from everybody as to the way the operation ran. This was not, and Judge Gilday, who heard the people, who heard from the evidence, said the CMRs, in combination with the way in which that operation was run, when you take someone's money and then you defer it to a lower level employee to do it, is a violation of Chapter 93A.
Well, I'm not sure
Is there an analogous case, like, so for example, let's just pick on lawyers, because why not? If a lawyer, somebody called and said, I need a lawyer for a closing for a real estate deal or something, and a paralegal answers the phone and a paralegal does the entire deal, and they do something wrong, would that be something for which the lawyer was liable?
If the
Or do you have a case?
I do not have a case, Your Honor.
Okay, I think we're going to have to leave it there unless there are any further questions from the panel. This is, I think, a very interesting case, and we've been helped take it from there. Okay?
Yes.
The case is now being recorded.
Good afternoon. Welcome to this sitting of the Massachusetts Appeals Court, which we are conducting by video conference due to the ongoing pandemic. Although we're conducting court in this fashion, all the ordinary rules of our court apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the next case, which is Georgia KRITIKOS versus Nicholas DEROSA. Case number 2021 P0495. Attorney James, we're ready whenever you are.
Yes, Your Honors, thank you. May it please the court, my name is Jamie James, and I represent Georgia KRITIKOS in the appeal as the appellant. Ms. KRITIKOS filed a complaint for modification in this matter. At that time, Ms. KRITIKOS had sole physical custody, and the child resided in Haverhill, Mass. And attended Haverhill Public Schools, and is considered, to this day, a child with special needs and on an IEP. The appellee, Mr. DEROSA, filed an answer and a counterclaim, and an amended answer and counterclaim. In none of his responses did Mr. DEROSA plead removal of the child from the Commonwealth of Massachusetts to the state of New Hampshire. The case proceeded to trial.
Go ahead, Judge Wolohojian.
All right. Go ahead.
You go.
All right. Counsel, in the ordinary case, when we're talking about removal, the term removal, it is a situation where custody has been determined when the parents are living in state A or state B, wherever they're living. And then after the custody determination is made, the parent with custody wants to move to a different state. In this case, there's no moving of the parents. The parents are staying exactly where they've always been, the father in New Hampshire and the mother in Massachusetts. So how is this actually a removal case as opposed to a, case determining the custodial placement of the child?
Well, the first thing, Your Honor, is that one of the biggest issues is that once the child is removed from the Commonwealth of Massachusetts, the Commonwealth loses jurisdiction over the child after 6 months, and the appellant's right to due process was violated. He also had to move schools and his communities. So therefore, Your Honor, my client did not have her due process. She was not able to bring in expert witnesses. She was not able
But counsel, let's test that proposition though. When at the time that the father asked for custody, he was already in New Hampshire. So at that point, the possible options were that the child would come live with him in New Hampshire or that the father would move to Massachusetts. So why was that not enough to alert your client this might be an issue?
Well, again, I think one of the most important factors here, Your Honor, is it has been held that a request for modification of custody is distinct from a request from relocation. And a complaint for modification seeking removal must provide notice to the opposing party of the relief sought. And again, the appellee could have moved to Massachusetts. So therefore, precluding the situation that we would have needed to bring in expert witnesses in regards to the fact that the child was special needs and that we're looking at different school systems. And the fact that he had lived all his life in Haverhill, Massachusetts, where his only sibling lives.
What was preventing you from making those arguments during the hearing on where custody should go?
Well, first of all, Your Honors, most importantly, again, I would state to you that my client is allowed her due process and being put on notice.
But that's a hyper technical argument. And I mean, even I think it's an EK it's one of the cases that precedes that you're just elevating form over substance unless you have some substance, counsel.
Well, Your Honor.
What was preventing you from making these arguments? You were aware of where father lived. Father was saying, I want custody.
Yes, Your Honor. First of all, I want to address what you said about EK. EK had filed a pleading that specifically asked for relocation. So this is not the same case as that had been filed. More importantly, Your Honor, the father had lived in Massachusetts, I believe, Your Honor, prior from the original judgment. So the father was living in Massachusetts. The father's fiance lives in Massachusetts. He works in Massachusetts. He has relatives who watch the child in Massachusetts. The presumption could have been made the same way, Your Honors, that he would be living in Massachusetts.
Well,
and
why
that he
is
should
that?
not
If the judge entered a temporary order with respect to this child, I believe, I'm going to say many months, maybe a year before trial, the child was living with the father in New Hampshire already before trial, right?
Yes, Judge. The judge.
For how long? For how long?
Approximately 2 years, I believe. He was living in Massachusetts. He was living in New Hampshire. However, he was going to school in Massachusetts.
Okay, that point I take, but then I asked the same question I asked before. What was preventing you from making the argument that the child needed to remain in the Haverhill schools during a trial about custody, where it was, I will use the word clear, but I could be a little unfair about that the intent was to have the child live with the father in New Hampshire as he had been for 2 years already? What was preventing you from making the arguments about the Haverhill schools?
We did make the argument, Your Honor. There was no findings in regards to the fact of the school in Haverhill. There was no findings.
Did you put in evidence on that?
Yes, Your Honor, we did put into evidence, and ironically, Your Honor, the judge in the lower court did not put in any evidence in regards to the fact that the school and one of their representatives had actually come and spoken on behalf of the child. Your Honor, we further, so that you're aware of, and it's in the pleadings. When I came into the case, the mother had been pro se. When I came into the case, I looked to put on experts, and I was denied my motion in regards to putting on additional experts. So, Your Honor, I didn't, my
That's
client.
a pretrial motion, counsel?
That was after the pretrial, Your Honor, that I came in.
I'm sorry. Was that motion before trial occurred or
Yes,
after
Judge.
trial occurred? Okay.
It was before trial occurred.
What was the rationale for denying you the opportunity to put on people about schools?
Your Honor, I believe that the case, the judge at that time had limited the number of witnesses, and I did bring on the representative from school. She did allow me that one opportunity to add one more witness when I was brought in as counsel. And again, that is not in any of her findings. I also was not allowed, Your Honor, to bring in any expert educational person that could have looked at the two school systems. Would you like me to
Father
continue?
does rely on the EK versus SC case. What's your view of the applicability of that case to this case?
Well, primarily, the most important factor of that case is that the father had pled removal. So although the facts of this case may be similar, the fact that the father had pled removal is a distinct fact. And as I stated earlier, that is the basis, one of the basis of Mrs. Kritikos's appeal.
Was that a removal case or a relocation case? Relocation of the child?
At that particular time, Your Honor, I believe the father was living in New Hampshire and that the
Right.
child was removed. There's a different standards of proof and compelling the evidence here, Your Honor, when there is a removal case. And most specifically, the person seeking removal must satisfy these tests by compelling evidence, a higher standard that is what is required in just changing custody. And the court looks at this, the lower court looks at this as only a custody case.
Well, the lower court made findings that went to both subjects of the tests that have to do with removal, right? The lower court said, father's been here long before there was any issues that had even arisen between the parties about the custody of the child. So those findings are sufficient, aren't they, to indicate that this was not something that was done by the parent in order to try to deprive the other parent of the right to have contact with the child. And then the whole rest of the findings are about the best interest of the child, which is the second part of the test. Why isn't the test satisfied?
It's not satisfied, Your Honor, specifically because the best interest of the child in a custody case is different than the removal case, where there is the real advantage test, but also the best interest of the
Real
child.
advantage test is the first prong. It's not the second prong.
Yes.
Real advantage has to go to a real advantage to the person who wants to move the child.
There also must be compelling evidence that the move will provide distinct advantages to the child such that relocation is in that child's best interest.
So there's okay. Your view then is that even though the father should be entitled to custody as in the best interest of the child, they have some heightened standard because they happen to live out of state?
Yes, Judge, there's five.
That sounds to me to be very problematic on a number of levels, counsel.
Well, Your Honor, every case that was proffered by my sister speaks about removal, where the litigant had pled removal. Mother has lost in this particular situation where Massachusetts, especially in this situation where Massachusetts will lose jurisdiction of this child after 6 months. Most specifically, Your Honor, the court never says that the child can be removed to New Hampshire, never uses those words. And my sister in her appellee's brief on page 12 states a serious misstatement because she says the trial judge also permitted the father to remove the child to the state of New Hampshire. That's not what the judge said. The judge said that the father could move the child to New Hampshire. And then it goes on to say the trial court declined to use the word remove or removal in its findings or judgment, and rather found that the father shall not move Maxwell from his current home in New Hampshire to another out-of-state location without prior order of the court, except that father may move to the Commonwealth of Massachusetts. Your Honor, the Commonwealth of Massachusetts loses jurisdiction after 6 months. Removal statute states permission of the court is required and doesn't say except in a change of custody. And I think that that's really important here to note that this is not just a change of custody case, this is a removal case. And the court made no findings in regards to the removal. And that's that's a very different part that Justice Blake from the appeals court made on the EK case. She specifically went through in her findings in regards to the appeal, all of the findings that the lower court judge had made in regards to the satisfying the real advantage test, as well as the best interest of the child. So all of those findings were available to Justice Blake in her response when the EK matter was being appealed. And again, EK, Your Honor, was a removal. The father was living out of state, but that he had pled removal. He had put the mother on notice. Your Honor, most specifically, in this particular case, if this case was to be allowed not to have pled removal, we're basically opening up the floodgates here, Your Honor, of every case that doesn't plead removal.
May I ask you a question? Did you put any of the trial exhibits into the appellate record?
I did not put any of the trial exhibits into the appellate record.
And we don't have the GAL report, right?
We do not have, we do not have the GAL report, no.
Okay.
But Your Honor, may I speak for a moment? The GAL report has nothing to do with removal. There is absolutely no mention of removal in the GAL report.
What's confusing to me about your argument is if there was evidence to support the judge's decision that it was in the best interest of this child to live with his father. It doesn't seem to me on this record that we can second guess that because we don't have any of the evidence. No one's put it before us. So we're just gonna have to accept that there was enough evidence to allow the judge to find that it was in the best interest of the child to give sole physical custody to the father. Then that necessarily includes the conclusion that the child would be living with the father where he lives, which is in New Hampshire. Does it not?
Well, two things, Your Honor. One is, by treating this as a custody case, there is not compelling evidence required. So if we're just treating this as a custody case and we're looking at the best interest of the child, there are 4 discrete factors. Those 4 discrete factors differ when there is a removal case from the Commonwealth of Massachusetts. And as Your Honor mentioned before, there's the real advantage test, which is accurate, which is also the best interest of the child. And in that case, when we're looking for a removal, it's 5 compelling evidence in regards to the best interest of the child, which is different. And
It,
the
it
court
can't
could have,
be, it can't be that the court has reached the conclusion that the best interests of the child are that it be with its father, but because the father lives out of state, you can't have the child live with the father because it's not compelling enough. That's the argument you're making to us right now.
Your Honor, the judge could have required him to move to Haverhill, Mass to allow the child to stay in school since it wasn't pled. The child was on an IEP. He's been diagnosed with autism. His friends and family and all of the community that he had been raised in his whole life lived in Massachusetts. Especially, Your Honor, the school system. He had a lot of support in regards to the school system that he was in.
So I do want to ask one further question, and I am being intentionally vague because the case is partially impounded, but I think you'll understand my question. So the father argues that the mother's beliefs, as she has posted them on various social media outlets, that might be inconsistent with the, I'll say, just characteristics of the son, called her ability to parent into question. What do you say to that?
I say to that, Your Honor, that the judge Armstrong basically adapted almost all of father's findings. And we amended the findings, Your Honor. There was no objection by counsel in our amending the findings. And in there, she basically stated in the amended findings that she supported.
Who's the she there? Who's the she?
Oh, I'm sorry, that the mother, in the amended findings that were not opposed by father, that she supported the son in whatever he wanted to do. And those are in the amended findings. And it's also in the supervision notes, Your Honor, which are again part of the amended findings, where it specifically said that what she said when the child told her that he, without speaking further, Your Honor,
personal characteristic.
Yes, Your Honor, I would specifically state, Your Honor, remand this case for a new trial. We cannot remand this case back for additional findings as the judge is retired. But I would state to you that in every case that has come before.
We're going to have to, your time has expired.
Thank you.
Let me just, there are no other questions. Otherwise, we'll hear from Attorney Rosnoff.
May I? Thank you. Good afternoon, Your Honors. May it please the court, Attorney Elena Rosnoff on behalf of the father, the appellee, Nicholas DEROSA. Your Honors, it is our position that there are more than enough findings, crystal clear findings, even the amended findings, that support the court's decision to allow Maxwell to live with his father in the state of New Hampshire.
Findings support the determination to award sole legal custody to the father.
Yes, sole legal and sole physical custody to the father.
But I'm only asking you about one half of that.
Okay.
What findings support the decision to deprive the mother of legal custody or even joint legal custody?
Yes, Your Honor, there were ample findings. In fact, the judge made findings specifically that it was the father that has always sought out the providers, especially when it has to do with the minor child's autism. The record is replete with the mother denying that the child even had autism. The medical records that were presented at trial and father's testimony all indicated that even as recent as 2018, the mother was calling the pediatrician to determine whether or not the child was actually autistic. She made further findings, Your Honors, that mother's legal custody questions were called into question because the minor child had a crisis incident right before he was removed from mother's care, where mother called the pediatrician, indicating that the child was having bad thoughts. The pediatrician indicated that he should have the child's crisis evaluated. Mother didn't inform the GAL or the father that this was happening, and waited 2 days to take the child for a crisis evaluation. Another finding that the court made, that the lower court made, I apologize, was that the mother took the son for invasive and unnecessary allergy testing because she was determined to prove that the child, who's autistic and afraid of needles, had an allergy because the father's fiance had a dog. She was additionally concerned about whether or not the child was able to get into therapy with mother, and also concerned about mother's views as to the child's characteristics. Mother, there was a history, and the judge put those in her findings and in her rationale as to why she determined that the mother, wasn't able to make the decisions. She also noted, Your Honor, that the GAL had actually recommended that the parties undergo parent psychological evaluations. The father complied. He took the next step. Dr. Stein, I believe, agreed to do the evaluation, but mother refused. And Judge Armstrong took very careful time to put in her findings that had the mother, undergone that evaluation, it might have made some recommendations that would have helped mother keep sole legal custody and sole physical custody. Mother's decision-making is just, the record is fraught with mother's inability to make.
Can I interrupt and ask a different question?
Yeah.
How was the issue of where the child should go to school presented at trial?
It actually wasn't. So Attorney James had indicated that she was allowed to bring in a person from the school. The person from the school just indicated that both parents would come to IEP meetings. And she also elicited testimony from her that, dad was late picking up the child from school after theater practice. It wasn't.
So let me put, thank you, but let me put a little bit finer point on it then. So you have an argument that I believe that there was plenty of notice of, which is that the father should have custody of the child. The father had temporary custody of the child for 2 years.
Correct.
Was there an argument made to the judge, if father has custody, the child should remain in the behavioral schools?
No. There was never such a determination because father actually—
No, not determination, argument. Because
No.
I've read the findings, and your opponent is correct that there are no findings at all with respect to the behavioral schools issue. And so what I'm trying to find out is whether that issue was raised to the judge in a way that the judge knew that it was an issue that the mother was saying, regardless of where the child winds up, in terms of who has custody, the child should remain in the behavioral schools because of the child's particular needs. Is that argument made?
No, it was never made.
Was the judge told that the child would be removed from the behavioral schools?
I believe my client testified that if the child were to live with him, he would be putting him in school in New Hampshire because that's where he resides. The child was in 8th grade at the time. He would have to go into a new high school regardless.
Well, yeah, but that wasn't my question. My question was the judge, and you're saying that the judge was told that the child would be put in removed from the behavioral school system.
If my client were to get custody, yes.
Okay, and was there any evidence about what that receiving school system would provide to this special needs child?
I don't recall. I can look back in the trial transcript and I can supplement with a.
If there's nothing, it doesn't look like the judge undertook an analysis to make sure that the receiving school system was comparable to the behavioral school system, correct?
Correct.
Well, why isn't that a problem?
Well, Your Honor, I would suggest that it's not a problem because the father was, I mean, if truth be told, the school that the child's in now is a higher rated school and he's receiving more services than he would in Haverhill.
It's outside the record, but
It is.
Isn't the point that the judge made the decision that the child would be in the father's physical and legal custody, so father then gets the ability to make those decisions?
Correct. I would agree that once the father gets sole legal custody, he makes the determination solely as to where the child is going to go to school. And, you know, I don't want to, we can't go off the record, and I certainly can't get into what the judge was thinking, but certainly the record is replete with examples of the father acting in the best interest of this child when it came to making decisions about his schooling. He hired education advocates to look at the IEPs, which there was testimony that the mother, you know, was just signing them, not really looking at them. Father was looking to put the child in more inclusive classes because he wanted him to get a high school diploma. Child is in mainstream. Was actually at the time of trial, father testified, child was put into 2 mainstream classes and doing well. Father initiated, I mean, the judge put all of this in her findings. Father initiated building blocks. Father noticed that there was something wrong when the child turned a year old. Father was the one that made the decisions. Even in the medical records, mother's own words were, she let the father take care of that. I think, Your Honors, you know, I want to just briefly, if I may, speak to just a couple of the expert question that came up. Counsel was asking for an expert because after the fact, you know, she was denied additional witnesses, but after the fact was trying to get a psychological evaluation of the mother into the record that wasn't approved by the court. And that was the expert that was denied. But Your Honor, the reason that I authored my brief the way that I did regarding the question of removal, good, bad, or indifferent, was this is something that if father always lived in New Hampshire, father actually never lived in Massachusetts, even at the time of the first judgment made in 2011. Father was always a New Hampshire resident. Father had, and judge made findings consistent with the fact that the father had the minor child in his care more than what that judgment gave. He was spending even more time.
Wouldn't it have been the better, your colleague again is correct that after 6 months, there's a material change in the law. Wouldn't it have been a better practice to also have included that not only does the father want custody, but that the father is going to move the child to New Hampshire? Wouldn't that have been the better practice?
Perhaps. And I agree that perhaps that, you know, if the court wants to look at that as a technical, but that's why I cited the law and the cases that I did regarding that issue, because it doesn't make it fatal, because you get to that, you're looking at this as a removal case. The real advantage is, well, father already lives there and has established his life there, owns a home there, and the child had been there for 2 years. But when you get to that second prong, it's all about the child's best interests. And clearly there are enough findings made by the judge, even on the 2 amended points that my sister pointed out. There were more than ample findings that showed that the child's best interests are served with staying with the father, him living with the father. The father got him into activities that the mother didn't. He got him into cooking classes. He was doing taekwondo. He was doing things that, you know, he needed to do. Mother, you know, Your Honors, there's also elements of alienation, which is another reason why it was in the best interest of the child to stay with the father. You know, I'd like to point out to the court, I mean, obviously you've read the briefs and you look at the record, mother came in on a modification looking to take father's parenting time away on Saturdays because the father is a hairdresser and works on Saturdays. And the father was utilizing his family, his sister, his aunt, his sister who had 2 children, and Maxwell was spending that time going ice skating and doing things with his family. And mother didn't think that that was a good idea. So she sought to take away father's parenting time. Father answered and counterclaimed after all this time because he said, the child's been spending all this time with me anyway. And unfortunately, you know, A GAL was appointed, a report was filed. The judge in her findings made references to the GAL report, which didn't ultimately make a conclusion about where the child should live. And I think in the procedural history, I laid out why. The mother stopped cooperating with the GAL, and the GAL sought to file an interim report as her final report. She wasn't able to get to that conclusion, but her interim report was enough for a lower court judge to make an emergency order removing a child from the custody of the mother. And that is not something that is done lightly in the probate court, having practiced there for as long as I have. Mothers, father never, and this is another part of the removal, father's intentions of having the child live with him were not to deprive the mother at all. In fact, he testified about the importance of Maxwell having a healthy relation. So I apologize about the minor child having a healthy relationship with the mother. The judgment put in several safeguards for the mother to be able to regain her parenting time. In fact, if she had gone through the steps as ordered by the judge, she would have climbed her way back to shared legal custody. If you look at the parenting plan that was outlined by Judge Armstrong in the judgment, there was
legal custody or shared physical custody.
Shared physical custody. I think shared legal, mother has the ability to request records, look at things, but I think that the findings are clear that the reasons why she gave father sole legal custody.
I think you misspoke and said shared legal custody, which I did not see in the order.
Yeah, no, just the shared physical custody, and allowed for holiday time. Even there was
I realize this is outside the record. Are the parties at that stage now? Have they gone through the various steps on the order?
No, Your Honors. Unfortunately, 1 month after mother earned her unsupervised parenting time, we had to file an emergency motion. Mother's parenting time is supervised again. And there's pending litigation in the lower court, unfortunately. And Your Honors, if there's no more questions, I see I have about 30 seconds left. I would rest on my brief.
Let me just look and check.
Sure.
Doesn't look like it to me. Thank you for your argument. Thank you, Attorney James, for your argument. They're very helpful to us, as were your briefs, and the case is submitted.
Thank you.
The case is now being recorded.
Good afternoon and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting today by video conference because of the ongoing pandemic. Although we're conducting court in this format, all the ordinary rules of our argument apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Trustee of Mary D. IATRIDIS Revocable Trust versus Ross, ANAPOLLE, and others. Case number 2021-P0059. Attorney IATRIDIS, we're ready whenever you are.
Thank you, Your Honor. May it please the court. My name is Maggie IATRIDIS, and I am the trustee plaintiff in this case and the appellant. And to Justice Englander's question, I am the attorney that you may have gotten confused about. A fair reading of both complaints in this case shows that all the claims were properly pled when the facts are accepted as true and all inferences are drawn in favor of the plaintiff as they must. The law supports the...
I'm sorry to interrupt you so early, but I have a ton of questions. And so I hope you'll be able to help me at least map out some specifics about your claim. I want to just verify that the only capacity the plaintiff is bringing his claims in is as trustee of the Mary IATRIDIS Revocable Trust. Is that correct?
Yes.
Okay, there are no claims being brought as a beneficiary or in your individual capacity, correct?
Yes, that's correct.
Okay, so I want to go through what I understand are the various transactions with which, and I'm just going to, so that my brain doesn't freeze, I'm going to call you in your attorney capacity as attorney IATRIDIS, but then in your capacity as the plaintiff, I'm just going to call him the trustee, so that, okay, so that we can be clear.
Okay.
The transactions that I understand the trustee is complaining about, I'd like to go through them one by one, if I may, to make sure I have certain core facts correct about them. Let's start, if we may, with the interest in the Azari house.
Okay.
Okay. I take it that you are complaining about a transfer that took place on August 20th, 2014. Is that correct?
No.
Okay. When did the transfer take place that you are complaining about?
The transfer took place after Mary passed away in 2015.
On which date?
On which date did she pass away, or which date was the transaction?
Which is the transfer?
I don't have a specific date. I know
Oh.
the allegation factually is that it's all happened after she passed.
Okay, so let's take it from here. Who was the transferor?
Well, the fraudulent document says Mary.
Who was the transferor? Was Mary?
According to the forged will, married to a nephew of hers who lives in that village of Isari.
Okay, so the transfer took place via a will?
Via a forged will, yes.
Okay, sir, I understand you want to put in your interpretation. I'm actually trying to nail down core facts.
Okay.
So, of date and things like that. So, so if it took place via a will, then wouldn't it have taken place at least as some sort of legal matter on the date of death, of Mary's death? If the transfer occurred via a will, then doesn't that sort of occur at the moment of death?
If it were a valid will, yes.
Okay, so we'll leave aside the validity of the will. The transfer that you're suing on with respect to, or the trustee is suing on with respect to the Azari house, who was the recipient of that property?
A nephew of Mary. His first name, I think, was Nicholas, and I can't remember the last name.
Okay. And you say all of that is clear in the complaint?
Yes.
Okay. Can we go to the Sifnos land?
Sure.
My reading is that there was a transfer of the Sifnos land on July 19th, 2013. Is that correct? that the trustee is complaining about?
That an illegal transfer, fraudulent transfer would have occurred on that date. Yes, I can't remember the exact date, but I think that's correct, 2013.
Okay, and that is from, again, I mean no disrespect, but I'm just going to use first names. Mary to Anna, is that correct?
Yes,
Okay. The Athens apartment, the transfer that the trustee is complaining about took place on July 22nd, 2015. Is that correct?
no,
Okay, what was the date of the transfer that you're complaining about?
the date happened somewhere 2016, 2017. It was a fraudulent transfer backdated to July 22nd, 2015. The complaint says that it was a fraud, that the document at issue says that certain people were on an island when they were not, and so on and so forth. There's lots of problems with that transfer.
Transfer was made by Demetrius signing as power of attorney for Mary.
Correct.
Okay.
That's what the document says. Yes.
Okay. And to Anna, is that correct?
Yes.
Okay. Then we have allegations in the complaint concerning
I
Judge.
just interrupt for one moment. So what you're saying is the backdating put that to a date in 2015 that was prior to Mary's death?
3 days prior to her death. Correct.
And then we have various transfers. I mean, sometimes they're characterized as gifts, sometimes as loans. I'm just going to call them money. Okay, just money. There are transfers of money from, or to, I should say, I take it to Anna, Stavros, and their respective spouses, right? There are allegations concerning those.
Yes.
And those transfers were made by Mary, correct?
Some were by her, some were by trustee Demetrius for
Okay.
her.
Okay. And I'm not trying to get into whether they were kosher or not. I'm just trying to find out the chronology. So some occurred before Mary's death, some occurred after Mary's death, or no, I guess some occurred before, they all occurred before Mary's death, some with Demetrius acting as her power of attorney. Is that correct?
Some were after her death, yes.
When he was acting as her, as trustee of her trust.
Correct, and as her power, yes, that's right.
Or, all right, well, he can't be operating as a power of attorney after her death, correct?
Well, the reason I'm sounding a little ambivalent is that some of these loans were made prior to her death by her or by him as power of attorney. And then after her death, they were memorialized, at which point he can only be doing it as trustee. So,
counsel, I have a really important question on that. I'll hold it. But when you say it could only be as trustee, I lose you, because it seems to me that the first person who would have any rights is her estate. And that's something you can just hold in your head and maybe address at some point later in the argument.
I can address it real quick and come back if it's not enough. Her will says whatever she has, to be very simplistic, goes to her trust automatically via a pour-over clause in the will, and it becomes an asset of the trustee of the trust. And that's what I'm trying to recover. So at that point, debt owed to Mary
But
goes,
there's a step that you're skipping as if it doesn't matter, and I don't know that it doesn't matter, and I don't know whether and how well it's pled, which is when Mary dies, her will has to be probated. And there has to be an executor of that will, and then the property has to be transfer. And I lost that, I have to say, in all of the briefing in this case. I just didn't see where that step was really addressed, because you draft everything as if the trust got assets without addressing the question of who the executor of the estate was and whether those assets actually transferred and poured over into the trust. That's the point that I want to hold on to while Judge Wolohojian goes through what I think is very useful.
Okay, so because it ties into this, because frankly, it's not clear to me from your pleading whatever poured into the trust upon Mary's death. And that's why I'm trying to go through the dates and the dates of the transfers. The last thing that I have on my list is Mary's 50% interest in the Newton house. Now, before her death, I take it your two parents were joint tenants of the house. They owned it jointly.
No, the allegation is they owned it as tenants in common.
Okay, they owned it as tenants in common in their individual capacities, correct?
Correct.
Individually. Then Mary dies, and her house, and that her half goes into the Mary Revocable Trust.
Correct.
Okay. At no point does Demetrius's half go into the trust, correct?
Into Mary's trust, that is correct.
Okay. So that half, you would agree, the trustee has no claim to.
Correct.
Okay. So then we're talking about Mary's half, which at one point when Demetrius was the trustee of the Revocable Trust, Mary's Revocable Trust, he then transfers along with his own half to the 288 Prince Street nominee trust, correct?
Yes.
All right. Now, you have not named 288 Prince Street Realty Trust as a party in this suit, correct?
I can't. I named Stavros IATRIDIS as trustee of the nominee trust as a defendant. So he's a defendant in this case in two capacities, individually and as trustee of the Realty Trust.
Okay, and you have not named either of your parents' estates as trustees, as parties, correct?
Correct.
How are they not indispensable parties, given the list of transactions and the timing as we have just gone through them?
Sure. First of all, nobody has ever raised that question. You're the first person that has raised this as a question. The estate, there's no claim against the Demetrius estate, so there's no reason to have that person in there. The trustee of the Realty Trust is the claimed owner, and not the trustee or not the executor, who is actually Stavros. He would just be wearing a third and a fourth hat. So he's here. He is the designated personal representative who has not been appointed by the court in the latest iteration of a codicil to Demetrius's will, which is challenged under the Superior Court case. So he's here just without that hat anyway. And then this partly goes to Justice Englander's question. I'm designated the executor or personal representative in Mary's will, and I have a petition pending to be appointed personal representative in the probate court, and that petition is still pending. So there is no executor, personal representative designated by the probate court in the Mary estate.
Okay,
However,
that's helpful to me. Can I just interrupt you for one moment? So you were named the personal representative in Mary's will.
as successor to Demetrius, who was the first personal representative.
What I thought. So Demetrius becomes the executor. Is the will probated? Well, let me ask the question very specifically. Does the complaint tell us whether the will was probated?
Well, it was filed. There was nothing to be, a probate case was created. And the claim was.
Is that in the complaint? So see, this is the reason I'm asking the question, so you can get to it. I think Judge Wolohojian and probably Judge Henry as well are on this page. At some point, you complain about a transfer in 2018 of a Newton house, of which everyone agrees Mary owned half. And my question is, did the trust have that half? And I'm missing a step as to whether the trust had that half, which is Demetrios becomes executor of the estate. He's the person who would transfer that, it seems to me, to the trust.
Yes.
Or did that ever happen?
Yes, it did happen.
Is it recorded? Is there a record transfer from Mary's estate to the trust?
No, but in the complaint, factually, I, as successor trustee of Mary's trust, alleged that that step should have happened and did not happen. And that was part of the ongoing fraudulent conveyance that occurred. I say that step you're asking about is missing. So that is
why isn't that a lawsuit against Demetrius as the executor of Mary's estate?
Because he was a puppet to some of the defendants. He could not understand, and he's the victim here. He didn't do anything wrong.
That's true, but even if that's true, you may have still sued the wrong legal entity. In other words, you may have sued, you haven't sued Demetrius as trustee, former trustee of Mary's trust, and you haven't sued Mary's estate.
Well, I'm petitioning to become the executor, and I am the trustee. So I am suing the people who did the bad acts.
Right, but they say you don't have any standing because your only standing right now is as trustee of a trust that never held the asset. There's nothing that shows that piece of property ever went into Mary's trust.
To the contrary, they allege below that step is unnecessary. That's not their case in here at all. They have said that that's not an issue at all, that Demetrius, as trustee of Mary's trust, conveyed it lawfully. That's their argument in this case. There's nothing in the record.
But did Demetrius transfer it as the trustee of Mary's trust, or did he transfer it as the executor of Mary's estate?
The trustee of Mary's trust is the signature block. And mind you, he's on his deathbed. He doesn't understand anything at that point. This is the defendant.
Do you need to have sued both? Do you need to have sued both him as in his capacity as trustee and the recipient of the asset, or just the recipient of the asset?
It's not just the recipients. The people who orchestrated the fraud are the ones who got sued. And it includes the recipient of the asset. Demetrius was sent home from the hospital in April because there's nothing he could be done. He was put on pain relief so he could just pass away peacefully. And a month later, they create all these documents that he has no clue about. These are all the factual allegations. The doctors confirmed it. I interviewed them. And so there's no need to sue someone who did nothing wrong. The bad actors here took a $2 million house through a fraudulent conveyance, and they rightfully are the defendants in this action. So for them to fraudulently make the transaction, perhaps they put the wrong signature block on the document that did it. That's not Demetrius' responsibility. he was, in all effects and purposes, he was gone. It was just a matter of days. So to say that you have to sue the victim, even to establish standing, is not true. Plus, the definition of the trustee of a state in our code and by statute includes a trust. So I am part of the estate suing for the wrongful thing that happened. And if I get appointed personal representative,
We're only bringing this suit, and we don't need to go over the territory that's already been gone over. You're only suing in your capacity as trustee.
yes.
So let me see if there are any questions that the other judges have.
Just to
I
be
do.
clear, so you're suing in your capacity as trustee because you're saying the assets should have been in the Mary Trust, or at least some of them.
I say all the assets being sought were either in or should have been in the trust, in the trustee's name and in control.
I don't
But
understand.
I think we just went through, there was only one that was ever in the trust, and that was arguably in the trust, which was Mary's half of the house in Newton.
And the
There's
rest,
There's nothing else that looks like it was put into the trust, correct?
no, the pour over clause puts it into the trust upon death without need for probate.
But they weren't in her estate at the time of her death.
They went into the trust at the time of her death by operation. It's analogous
So
to that.
stop. Let's take an example, okay? Because we're asking the same questions. Let's take the one that you say there was a fraudulent backdate, okay? So the backdating would show that that asset was transferred before Mary died, not part of her estate, if the backdate were accurate, right?
Right.
You say, it was actually in her estate when she died. And this was backdated. This transfer occurred in 2016 or 2017. Was this asset, I think this might be the Cisnos land. Was this asset listed as an asset of Mary's estate at probate?
No.
Did anyone sue over that?
Me.
No. Did you file a lawsuit with respect to the estate? I think you have 1 year in order to try to get stuff put into the estate, make sure the probate is done properly. That lawsuit was never filed, right?
Because I was told that Greek property doesn't go on the list of assets in the Massachusetts probate. Only the property in Massachusetts gets listed on the inventory of assets.
Let me ask this in another way. The only way that things were going to get from Mary into her revocable trust was if they were part of her residual estate, correct? Because the provision in her will was that the residuary of her estate would go into the trust. So the quest she made otherwise would, whatever. But if
Would
it
happen
was part
first,
of,
right?
right. But the residual, isn't it the job of the probate court to determine what is and is not in the estate and what was or was not in the residual portion of her estate?
No, the two courts, I could choose which court, and Superior Court has concurrent jurisdiction.
That's not
Okay,
answering
but
the
you
question.
haven't brought a suit challenging, seeking a determination of what was or was not in Mary's estate at the time of her death, or determining what was subject to the residuary clause. I'm not even sure that we have the will. Well, in any event, I don't even think there's anything for you to answer there. It's not a question. I have one final question. Is there anywhere in the record where we're going to find a copy of the trust? I didn't see it.
not in the Superior Court case, I believe. I think it's been quoted, but in the probate court you would. I'd like to make 2 points to respond. One is the pour over clause operates like a joint account. If you have or a beneficiary to an IRA account, the beneficiary on death gets it, whatever's in that account, without having to go to probate. They can pick up the phone, write a letter and say, I'm the beneficiary, I get it. It does not go through probate. The same thing with anything that went through the any residuary assets that went into her trust through the pour over clause do not go through probate. They go right to the trust. So with all due respect,
Well, you say that, I don't see any briefing on it. And I have another question that is a follow-up to that, which is, if that's true, then Demetrius's trustee becomes the trustee of the trust in 2015 and has the ability to transfer assets out of that trust, right?
Correct.
Okay.
He does. And the point is that you don't see the argument because it was never made by anybody. Never. This whole line has never been raised below, not even in the appellate briefs, nowhere. So as you're contemplating, there is, maybe we can do supplemental briefing if that's really an issue you're going to hang a hat on, because that would.
Sir, I have to say, we're just trying to understand the case.
Okay.
One of the arguments that was made in this case is that you violated Rule 8. You didn't give us a short and plain statement of the facts. And I have to tell you, that sure as heck seems right to me. Okay, it's an enormous amount of material for us to parse through, some of which is clearly irrelevant and had no place whatsoever in your complaint. So we're doing our best, which frankly, you've gotten an enormous amount of time as we're trying to figure out whether you've got claims here or not. And we're going to do that fairly and impartially.
All right. So I just want to say none of us has made up a mind, Attorney IATRIDIS, but you are out of time, and we're going to have to leave it there now and hear from the other side. Thank you for your argument. I found it helpful.
Thank you.
Let me get my little crib sheet with the order here. Attorney Hirsch, we'll hear from you, and you have 7 minutes.
Thank you, Your Honor. What I think would be most helpful to the panel at this point is if I were to go through each of these allegedly improper transactions, as Judge Wolohojian did, and point out to you why it's our position that each is fatally flawed for a variety of reasons. If we start with the Asari transaction, that's a piece of property that was owned by Mary during her lifetime. There was a will that Maki alleges was forged that passed that piece of property to a distant relative of Mary's. If in fact we take her date of, yes.
The same will that has the residual clause?
It is not, Your Honor. This is a will separate and apart from the one we were just talking about. It, as far as I know, only has any bearing on the disposition of the Asari house.
How can a person
she had more than one will?
This will was apparently executed in Greece. I don't understand it either, but that's the allegation in the complaint, that there was a will executed in Greece, that it was a forgery, and that therefore it was an improper transfer. That's the allegation in the complaint. But Maki,
are we accepting true, therefore, that there are 2 wills?
I have done so for purposes of our argument and our briefing with respect to these issues. Maki, as trustee of Mary's Trust, has no standing to bring a claim with respect to this allegedly improper transfer of the Asari house, because this property was never owned by Mary's Trust. The claim is also barred by the statute of limitations.
Why was it never owned by Mary's Trust? Yeah,
That,
your Maki says, sorry, I'm using first names because there are a lot of IATRIDIS on the phone, but he says that was a forgery, that when she passed, she owned the asset, and that it poured over as a matter of law into the trust.
to the extent his argument is that there was a forgery, that contention would need to be pled with particularity. We're talking about somebody committed a fraudulent act by creating a document behind Mary's back and signing it without her knowledge. There are by far not sufficient facts to plead that allegation with particularity, as Maki is required to do under Rule 9b. Maki claims in his complaint that therefore, pursuant to the Asari will, this property passed upon Mary's death to this distant relative. Even if that's the case.
I'm not familiar with someone having two wills, or one US will and one will from another country. So if the US will governed, then was the Asari house in the residuary and should have poured over into the Mary Trust?
If in fact we accept as true that the property should have flowed into the Mary Trust, we still have a problem with this claim. At least, as I said, there's a failure to state a claim with the requisite particularity. And on top of that, you've got a jurisdictional problem. All of these allegedly improper transfers that have to do with Greek property are not properly before this court. In the first instance, Maki claims, well, the Mary Trust should have owned these pieces of property. And if it had—
You're gonna lose me here again, but and I'll tell you why, but I don't know that we need to spend a lot of time on it. I think that that a court with jurisdiction over the person of all these people, if they actually received the property, even though the property is in Greece, has the power to order them to transfer the property. There may be issues with respect to actually affecting that transfer, but if they've got in-person jurisdiction over those people, my understanding is the court can enter that order. And I don't think any case has been cited to us that suggests otherwise.
That is correct, Your Honor. The cases that were cited have to do with ancillary probate proceedings, which are analogous in certain respects to these. When a decedent dies holding property outside of the Commonwealth, whether that be in another state in the United States or outside of this country, ancillary probate proceedings need to be commenced in order to deal with those pieces of property. And then the Massachusetts—
You're talking about real estate. You're talking about actually getting the property recorded and affected in another country. And then there'd be questions about whether the other country will give full faith and credit to whatever happens here. But if you have in personam jurisdiction, you can order the transfer. Whether that actually happens is a different question.
That's fine, Your Honor. Let me move on to the Sifnos land. The Sifnos land, as Judge Wolohojian pointed out, was owned 20% by Mary. And the allegation is that Demetrius, in his capacity as Mary's attorney-in-fact, transferred Mary's 20% during Mary's lifetime on July 19th of 2013. This claim should have been brought against Demetrius's estate if in fact Demetrius is alleged to have improperly made that transfer. It should have been brought by Mary's estate. Demetrius, as Mary's attorney-in-fact, owed a fiduciary duty to Mary. So to the extent he breached that fiduciary duty, Mary is the one withstanding and now her estate. Also, this claim is barred by the statute of limitations as having—
Well, but I thought, who was the original personal representative of Mary's estate? Wasn't it Demetrius?
It was, Your Honor.
How does the statute of limitations run if the wrongdoer is the person who was supposed to have brought the action? Because we can't expect that it's going to run while he's going to supposedly sue himself.
Your Honor, that's why there is a statute that contemplates exactly this situation. Mass General Laws, Chapter 230, Section 5 provides that in a situation where an heir wants an estate to bring a particular claim and the personal representative says, no, I won't do it. And oftentimes it's for precisely these reasons. I'm not going to sue myself. then the heir has a right to bring that claim. And that wasn't done here, and it's too late now. Your Honor, with respect to the Greek apartment, the allegation with respect to the Greek apartment is that Demetrius signed documentation July 22nd of 2015 in his capacity as Mary's attorney, in fact, transferring the apartment to Anna. Now, Your Honor, Maki argues this afternoon that there is an allegation in the complaint that this purported backdating took place in 2016 or 17. I do not believe there is such an allegation in the complaint. My understanding that he alleges there was backdating, but doesn't say when. Possible it happened within 2015, if it happened at all, and we would still have a claim that is time barred. But putting that aside, even for the moment, we are left with another standing problem, and the same problem we have with the Sifnos property, which is that this claim has been brought against the wrong person. The Newton House. The Newton House is the only allegedly improper transfer where we find arguably.
Okay, but just indulge me for a moment. Let's assume that Demetrius, at the very end of his life, really had no capacity. And in fact, somebody else was signing his name. Then is he the party that needs to be sued, or is it the party, just to indulge me, that the party who signed his name pretending to be him is the party who needs to be sued?
Well, there's no instance here where the complaint alleges that somebody signed for him. There's allegations of undue influence, that behind the scenes, people were engaging in conduct that persuaded him to do something, and that perhaps he was vulnerable.
So
but those are all,
for purposes of the question, that's sufficient. Can you just assume and now answer Judge Henry's question? Let's assume that was shown.
Yeah. So let's say that it depends on which claim we're talking about, but let's say we're talking about the declaratory judgment claim.
Take the Athens house that you're just talking about.
Okay, the Athens house and the other pieces of property, if you want a declaration, as Maki does, that these transfers were improper, then all of the interested parties need brought into the mix here. And whether or not somebody allegedly signed Demetrius's name, if the paper says that Demetrius, in his capacity as trustee, made a transfer, then whoever the trustee is, or the personal representative, whatever fiduciary capacity we're talking about, needs to be brought into the mix here so that they can have an opportunity to be heard. Otherwise, these declarations that Maki seeks will have no force and effect. Everybody with an interest has to be a part of this case, whether or not you believe that the underlying wrongdoers are Anna and Stavros or whomever.
Well, okay, but assuming that somebody tricked Demetrios into signing this, and I'm sad to say we do get these cases, then what's the point of bringing him in when in his capacity as trustee, when he is deceased, and we do have the successor trustee in the case?
Well, you still have the problem of, if Demetrius was tricked and Demetrius was the victim, then Demetrius has a claim. And Maki has attempted twice now to be appointed as his personal representative so he could bring claims for Demetrius if Demetrius is really the victim. But he has twice been turned away from the court. Both petitions were dismissed because he didn't have
standing. I lose you on it's Demetrius's claim. As I understand the allegation described to us today, it is that there was a backdating of something that otherwise was part of Mary's estate.
That's right. I was just responding to Justice Henry's question that if Demetrius had been the one that was wronged, if somebody signed for him.
Demetrius is the one who signs it. Right. So he signs it. The argument is, or the allegation is, I understand it, I may have it wrong, is that he was unduly influenced to sign that. Okay. And that if that were true, it would have been part of Mary's estate.
Yes.
Your opponent says that poured over on her death. Therefore, it was part of the trust. So now the trust comes in as the person was standing to try to get that property back that was transferred out with undue influence imposed on Demetrius. Why isn't that a claim?
Because at the moment, the trust does not own any of this property. So the way in which to bring that claim would not be in his capacity as trustee of the trust. The underlying transfer that happened during his parents' lifetime is what's being challenged. For example, with respect to what the example you just gave, if Demetrius was unduly influenced to do something that was inconsistent with Mary's wishes, then again, Mary was wronged. Demetrius, as her attorney, in fact, breached his fiduciary duty to Mary, and Mary has a claim. And the way in which he could have brought, excuse me, Mary's estate. Right, and Maki is well aware of that, which is why he has tried to be appointed as personal representative of both of those estates.
Okay, so can we go to the Newton House, which I think is the last on the list?
Yes. So the Newton House, again, this would be a claim against Demetrius's estate. This is a document that Demetrius signed.
I think we need to take it in two halves because Attorney IATRIDIS has conceded, I think today, that with respect to the half that belonged to Demetrius, he's not seeking any claim. He concedes that that was never part of the revocable trust. So let's just talk about Mary's half.
Yes, Your Honor. Mary's half, the 50% that Demetrius, in his capacity as trustee of Mary's trust, transferred to the realty trust that he created. So to the extent that Demetrius did something outside of the bounds of his authority as trustee, the claim is against him. To the extent that—
Whoa. The claim is he was unduly influenced. It's a claim of the trust. As to this one, the allegation is he transferred it as trustee of the trust. Leaving aside all the other questions of whether the trust actually had that asset yet, okay? If you assume that the trust had the asset, why isn't that enough? You unduly influenced, here's the trust saying this asset, which was transferred from the trustee was unduly influenced to transfer that. How can that not be a valid claim?
Well, I'm not suggesting that he doesn't have standing. That is not what I'm saying here, because assuming what he's alleging is true, even if there was no probate of that 50%, I'm even giving him credit that this 50% made it into the Mary Trust. So I'm not suggesting that's not standing, but Demetrius, in signing a document, was part of the wrong. And
he doesn't have to sue Demetrius. He can sue the people who unduly influenced Demetrius. That's my understanding of that claim.
So if that's the lens through which we're viewing this, then he's failed to state a claim. If he's claiming, well, if he's claiming undue influence, which is subject to the 9B heightened pleading requirements, he's got to tell us, what did Anna do? When did she do it? What did she say? Nothing. None of that is.
No, isn't it sufficient to say this transfer occurred within the week before Demetrius's death? As of the time that Demetrius passed, as of that time, Demetrius was incompetent to have done that. And the people who aided in effecting this transfer were A, B, C, and D. Why isn't that enough?
Because that doesn't satisfy the pleading requirements of 9B. There's no specifics whatsoever about what my clients are alleged to have done in connection with that. This is a vague, sweeping allegation that it must have been them. They were involved, but
so
that's
you're
not
saying
enough.
There's not, if when I go into this complaint and look around for who did what with respect to this transfer, one thing I know that's in there is that Attorney Taylor is involved in the preparation of the documents. That's in there specifically, right?
Right.
Okay, and you're telling me I'm not going to see anything that alleges that your client, Anna, or Mr. IATRIDIS Stavros were involved in that transfer?
No, and I can point you to the paragraphs and the pages.
Somebody was involved.
It's not alleged in the complaint. It's on pages 151 through 154 of Record Appendix 3. That's the section of the third amended complaint that is titled Fraudulent and Unauthorized Transfer of the Newton House. So when Your Honor has a moment to review those sections, there are
I'm
not
looking for them now, if you can give me a
sufficient-
moment. All right, I've got it right here. What were those numbers?
Record Appendix 3, pages 151 to 154.
Well, what are
And
the
there's-
paragraphs of the complaint?
Paragraphs 136 to 165 of the third amended complaint. You're welcome.
As I understand it, it's alleged that the house was transferred to the 288 Prince Street Nominee Realty Trust. Has
Yeah.
that entity been named in the suit?
I believe that Stavros IATRIDIS has been named in his capacity as the trustee of the Realty Trust. One thing I would point out is a nominee trust, the owners of the nominee trust are the beneficiaries. The Demetrius Revocable Trust is the 100% owner of the nominee trust, and that trust has not been named as a defendant in this case. And so to the extent that a determination of title is being sought with respect to Mary's 50% share, I believe that they would be an indispensable party.
So the allegation then you say is inadequate because of 9B obligation for undue influence is 158. Upon information and belief, Stavros, Anna, Zahopoulos, and Taylor arranged for the transfer to the Realty Trust and arranged for Demetrius to go to the embassy to sign the related legal document.
Right. That's not enough as far as I'm concerned. Upon information and belief, without a date, without a representation, without anything else is not enough. That is the only paragraph in this section that mentions her name.
Can you tell me again, because I didn't catch it? Well, first of all, I take it that the details about the 288 Realty Trust are not in the record here before us? They're not complaint?
The details of, I actually don't, I don't know. I don't know if the complaint alleges who the beneficiary of the Realty Trust is.
All right, I think we're gonna have to leave it there unless there are other questions. Here. Okay. Mr. Stavros IATRIDIS.
Yes, good afternoon. It may please the court. My name is Stavros IATRIDIS. Along with Helen Sasunis, we filed a joint brief, defendant appellee brief, requesting that you could confirm the lower court ruling that everything was dismissed. At the heart of the matter is here are the facts or the lack of facts, specifically to the plaintiff's claims that there's money to be collected. The facts are that when my mother died, there were no financial assets that would have been subject to the Massachusetts probate process and would have transferred, poured in, skipped it, doesn't matter. There wasn't any to speak of. My mother was sick, or Mary was sick as early as 2007. She didn't give any loans out.
I take it she owned half of the Newton house, and you're saying that automatically passed without going through probate into her trust?
My understanding, when I was speaking just for financial assets, not real estate assets, my understanding was that my father, who filed an informal probate, and his attorney, Barry Walensky, they listed that half house as her only asset when they filed that probate bond. There were no other assets filed in that probate bond listed for Mary IATRIDIS. My understanding was that my mother, Mary, and Dimitri had a joint bank account, and that became my father, Demetrius's property upon her death. Doesn't go to the trust, doesn't go through probate. So there were no assets in 2015 that would have poured into Mary's trust. Mary's trust never gave any loans out, so there's no right standing to collect any purported loans that the plaintiff is claiming. Judge Henry kind of called him out on it, gave him room to amend, and in what we call the cut and paste third amended complaint, he punts and says, well, these were years ago, we need discovery to find a cause. Basically, there are no facts that would give support to his claim that there are any assets to collect. He does mention two promissory notes But he also tells you that Mary was not a party to those. The 2016 note came a year after she passed away, and it was signed by Demetrius. The 2013 note, it was basically forgiven by Demetrius, who signed it in as many capacities, both as Mary's trust, Demetrius' trust, and it's in the complaint. It clearly says that the maker, myself, could pay one trust or the other, and is forgiven upon the death of both. So there's really no assets that the plaintiff has alluded to that would have either poured to the trust without probate or through her probate, because she didn't have it.
I think we understand your argument and your time has expired. We
I
appreciate
just
it.
feel the need to say for the record that the Judge Henry he's referencing is not this Judge Henry and has no relation to this.
Oh,
Judge.
I apologize.
That's
Sorry.
okay. It's confusing. It startled me when I first read the record.
Okay.
Okay. Attorney Finkel. Attorney Finkel?
on
Your
mute still.
yourself.
There we go. Can you hear me now?
Yes.
Okay. May it please the court. The only claim that's really briefed by Mr. IATRIDIS in his briefing is the legal malpractice claim that is brought against Attorney Taylor. And I submit that Mr. IATRIDIS, as trustee of the Mary Trust, does not have standing to sue Ms. Taylor for legal malpractice, and really there are two reasons. The first is that in the second amended complaint, which is a verified complaint, particularly in paragraphs 425, 428, and 429, it establishes that Attorney Taylor was hired to be Demetrius IATRIDIS' estate attorney, specifically replacing Attorney Barry Walensky, who was fired by Demetrius, and an entire email string is actually pasted into the complaint that describes the situation as to why Mr. Walensky, I'm not able to hear you.
Judge
Wolohojian,
Wolohojian, yeah, there.
Say that. You are going to have to speak closer to your microphone. It's very difficult to hear you.
I apologize. Can you hear me now better?
A little bit. I don't hear you at all. Don't hear you at all now.
Can you hear me now?
I can. Can I ask you a question? Because I did hear your argument. At paragraph 573 of the second amended complaint, Taylor is an attorney who represented Demetrius as trustee of the trust. At paragraph 575, Taylor was responsible for drafting the legal documents to transfer Mary's half share of the Newton house out of the trust and into the realty trust. Why isn't that sufficient? So that's a direct allegation that your client was representing the trust.
First of all, well, again, that's in the complaint. But the issue there is that this is a claim of the beneficiary that the trustee is trying to assert against Attorney IATRIDIS is trying to assert against Attorney Taylor. The issue there, and it's the Spinner versus Nutt case, that a beneficiary cannot bring a claim against the attorney of a trustee. And again, most of these allegations that are being asserted against Attorney Taylor
He's
are
bringing the claim. I don't understand. He's said several times, he's not bringing the claim as a beneficiary. He's bringing the claim as a trustee of the Mary Trust. He's bringing it against a lawyer who previously, he alleges, it may be factually incorrect, but he alleges represented the Mary Trust and did it to transfer out an asset of the Mary Trust.
these specific claims that are being asserted really arise and are akin to a breach of a fiduciary duty, that are claims that the beneficiaries would allegedly have against the trustee for allegedly improperly transferring the half of the house into the nominee realty trust.
I don't understand that either. If I'm representing a trust and I believe that the prior trustee, when he had no capacity, transferred an asset of the trust, and the lawyer for the trust prepared the documents to do that, why can't I, as the successor trustee, file a malpractice case that says you prepared documents to transfer an asset and had someone sign it who you should have known was completely incapacitated?
Well,
Why isn't that a valid claim?
Well, first of all, it's factually it's invalid because the Mr. Demetrius IATRIDIS was in Greece in front of an apostle at the United States Embassy signing the documents. Attorney Taylor was not in Greece when these documents were in fact signed. At all times that Attorney Taylor was representing Mr. IATRIDIS, Demetrius IATRIDIS, there's no evidence, certainly within the complaint, that suggests that he was incompetent at those times. As a matter of fact, if you look at paragraph 425, at the time that Barry Walensky refused to remove Mr. Mackey IATRIDIS as the power of attorney, specifically states in that particular email that there is no, he's not questioning his competency. I would also suggest that these documents that were, again, signed in Greece at the United States Embassy before an apostle, that it occurred at least a month before Mr. Demetrius IATRIDIS' death, which, of course, competency is an issue that it's depends on what happens at the time that the documents are actually signed.
Let me check to see if there are any other questions. All right, we have your argument. Thank you very much. Attorney Katzen?
Thank you, Justice May. Yes, can you hear me?
Yes, perfectly.
Great. May it please the court. I don't want to be the tail that wags the dog. I haven't been throughout the case. I represent Ross and Shoshana ANAPOLLE, who happened to rent the house from the Demetrius half, what we've been referring to as the Demetrius half. The thrust of our motion to dismiss and our appellate argument is and always has been that the Mary half is a stranger to our lease and can't come in and demand that we breach our lease and effectively resolve an aspect of this case in his favor, or give him a preliminary by paying him half of the rent, or give him a preliminary injunction by paying all of the rent into court. It's just not right. It's not fair. And I think that's clear. And there's been no case law cited that would support that.
Can you tell me how that works? Your clients rent only, who's the, under the lease, who's the lessor?
So the lease ran from, I believe, March of 2017 to, March 1st of 2018 to the end of February of 2019. That lease was with Demetrius. It was signed when he was alive by Anna as his power of attorney. And that's in the record at volume 3, page 168. My clients had 2 children in the house at the time, and they asked to extend the lease for another 3 months. And in December of 2018, after Demetrius had died, an extension was signed. And that was signed by Stavros as co-trustee of the Demetrius Trust, also part of the Demetrius half.
Wait, as the Demetrius?
In other words, when Demetrius, yeah, when
the two Realty Trust?
No, it wasn't the Realty Trust. It was with the Demetrius Trust. The Realty Trust is a nominee trust. The principal or the beneficiaries of it are the Demetrius half and the Mary half, is my understanding of it. My client originally contracted with Demetrius, and for the last 3 months had a contract that was signed by, of course, my client didn't control that. That's what they got. They got a document that said it was Stavros as co-trustee of the Demetrius IATRIDIS Trust. And that's also in the record just after the first lease. It was in our
To
motion.
be clear, are your clients still living there?
No, they were out of the house by the end of June of the year that the litigation was commenced. By the time Maki, came in and started making demands of them, there were only another 6 months left on the lease. And by the time the motion to dismiss was argued, they had left.
So that's what year?
2019.
I'm going to ask in light of that, and you can just file this separately, Mr. IATRIDIS, after this argument. Why don't you just file something with us telling us whether, in fact, you're still pressing claims against the ANAPOLLE? Okay? Because that seems to me like a little bit of a tempest in a teapot here, given where things are as just represented to us. Okay, thank you.
Thank you.
And then Attorney Higgins.
Thank you, Your Honor, and may it please the court. I represent Yorgos Saraboudalis, who is a retired lawyer who lives in a village near Athens in Greece. And in the trial court, we moved to dismiss all the claims against Mr. Saraboudalis for lack of personal jurisdiction over him under 12b-2, also for failure to state a claim under 12b-6. So we've joined in the appellant's arguments under 12b-6, and I'm just separately addressing here today the jurisdictional argument under 12b-2. So in the lower court, the plaintiff contended that personal jurisdiction existed over Mr. Saraboudalis under Section 3B of the long-arm statute, which required the plaintiff to show facts that his causes of action arose out of my client's contracting to supply services in the Commonwealth. And I would suggest to Your Honors that there are simply no facts in the complaint suggesting that Mr. Saraboudalis agreed to supply any services in the Commonwealth. Everything the plaintiff alleges that he did occurred in Greece, involved property that was located in Greece. With respect to the due process analysis, there's no facts alleged suggesting that Mr. Saraboudalis purposely availed himself of the privilege of conducting business in the Commonwealth, nor would the assertion of jurisdiction over him be reasonable under the Gestalt factors. And because the plaintiff did not meet his burden in the lower court of alleging facts necessary to sustain the exercise of personal jurisdiction over Mr. Saraboudalis, this court properly can affirm the dismissal of the claims against him on that ground. And otherwise, I'm happy to rest on my briefs, but I'll answer any questions that the court has.
Let me see if there are any questions.
All right. I'm sorry, does the blue brief, does the appellant's brief argue jurisdiction?
Yes, Your Honor. There is a section of the brief, of the appellant's brief, that does argue jurisdiction.
Perhaps Judge Wolohojian, you can direct the same question to
Yes,
Mr. IATRIDIS about that claim.
Yes, I was going to ask you, but I also think I'm going to ask you this question, Attorney IATRIDIS, but you don't need to answer it here. Let us know in the same submission whether you're still pressing any arguments with respect to the dismissal of the claims against Attorney Saraboudalis. It's frank. I'll just speak frankly. It's very hard to see how you've established any kind of personal jurisdiction on this record. So, and we may as well narrow out the things that are not really at core here. Do you hear me? Yes, okay. I also want to thank everyone for their arguments, but I will also give you an alert, a heads up, that I anticipate we will issue an order seeking supplemental briefing on some particular issues. And I'm going to ask that if we do that, and when you respond, to try to we will give page limits, but to try to really focus without too much editorializing. We know the substance of the complaint is that essentially there were sharp practices designed to transfer assets out of Mary's ownership to circumvent the trust. Okay, that's what we're going to essentially think is the essence of the complaint. We don't need to hear editorializing. It's helpful to us if your briefs are as concrete as you can make them. And that's only if we ask for supplemental briefing. But I anticipate we may. Okay? And with that, the case